I would like to ask everyone to please take their seat. We are getting ready to officially start the Task Force on Child Abuse Investigation Processes Committee hearing. I would like to remind everyone in the audience to please mute your phone. If you have to take a call, we would ask you to please step out of the room to take those calls. Today is October 16th, and at this time, I will officially call the meeting to order, and I would ask that you call the roll.
Senator Barrow.
Present.
Present. Dr. Birch. Judge Green. Judge Guillory. Ms. Hadley. Present. Mr. Hanneman. Present. Dr. Hook. Present. Ms. Moody. Present. Captain Patu. Honorable Russell. Present. Ms. Shelton. Present. Captain Sanji. Present. Dr. St. Germain. Present. Dr. Thurber. Present. Ms. Wascom. Present. We have 11 members present.
All right, thank you so very much. A quorum is not required for this task force hearing, so therefore we do not have to meet a certain number. However, I do want to thank all of the task force members for being present. Thank you for your commitment to this very important issue. And in your packet today, you should have a survey that was done that was given to many of the judges. It actually lets you know how many judges actually participated. So we had 23 judges to actually answer these questions. What I would like to do, because you may have just received this morning, is I would like to pause and give everybody a few minutes to kind of glance through these questions and to see the responses. While the members are doing that, we do have 3 judges here who are going to actually come before us and give testimony and answer questions. Over the last couple of hearings, we've had a lot of questions as it relates to the judiciary process and how the cases regarding children, child abuse, etc. are handled. And so we have many of the retired judges, those individuals who, if you would, please just come to the table, who are going to share insight, currently not sitting judges, to answer some of the questions that we may have. In addition, Judge Belford, yes, sir. Yeah, come on up. So as I stated before, over the last year or so, we have had multiple hearings. There have been many questions, and as a result of that is what brings the judiciary branch of government before us. Certainly, I do want to emphasize and make sure that I state that we do understand that there are 3 branches of government, and we recognize that we are the legislative branch of government, so we are not trying to infringe on what the judicial branch of government responsibilities are, but we just are looking to give further clarity, understanding of where we have loops, we may have gaps in the system where we see apparent breakdowns. Many of my colleagues have received numerous calls, complaints, concerns relative to cases that have gone before the judiciary in terms of how they were handled. And as a result of that, especially as it relates to child sexual abuse, in some instances, it appears that there were not good resolve or no resolve. And so as a result of that, we are attempting to see where the breakdown may actually be happening, to see if there is a legislative fix for those issues or if there's something else that needs to be addressed. So with that said, I will see if the task force has had an opportunity to look over the survey. I believe the survey was well put together. I do want to thank all of those who played an integral role in helping us to craft this, to send out to our judges so that they can respond to us. I believe that these were awesome questions, and some of the answers to me, kind of leads to some of the concerns that we have actually heard. So as a result of this, if the task force is ready to hear from the judicial branch, we can get started. Have y'all had an opportunity to glance at? Okay, all right. Okay, great. Well, let's get started. So we will ask everyone to introduce themselves, tell us what level of the judicial branch you actually served on, and what role you've played as it relates to child custody cases, family court, etc.
My name is Guy Holdridge, and I was a district court judge for 24 years on the 23rd Judicial District Court, which is Ascension, Assumption, and St. James Parish. And then for 10 years, I was on the Court of Appeals. I recently retired. I am the director of the Louisiana State Law Institute, but I'm not here in that function here today. I'm here only as a retired judge. I did have quite a bit of experience in family law cases in that the first 6 years I was the very young judge, and all of the other judges on the 23rd were much more older than I was, so they gave me the pleasure of hearing every family law case in Ascension Parish for 6 years. So it was quite a wonderful experience every week, having to hear cases generally on Fridays starting at 9 o'clock and finishing. Hopefully, I tried to finish by 7 o'clock so I could go to the football game at 7 o'clock. Many days we didn't get finished on that time. But as far as child abuse, sexual abuse, and other things, I just would like to say that probably the judicial system that we use is flawed. I think everybody would recognize that it's flawed. Probably the worst outcome that you can hope for is the way we handle cases, in that we make each party go into court and say the most vile and horrible things that they can say against the other party. Then the judge has got to make a decision, either joint custody or sole custody or visitation, all that. And then the judge at the end has to say, well, y'all go and y'all get together and be friends and do what's best for the best interest of the children, after they've spent thousands and thousands of dollars trying to say what was bad about the other party. Now, there is, I don't know if you realize, the legislature passed 2 or 3 years ago, there is a collaborative divorce process. If everyone has money, both parties have money, both of the parties have mental health professionals helping them. Every child has a mental health advisor that helps the child. We appoint attorneys for the children, and everybody gets together generally in a collaborative method and comes out to a resolution. But that requires a great deal of expense for every case where everybody can have a mental health professor and do that. What happens in the normal case? In the normal case, one of the spouses or one of the parents says there's abuse. They go to the sheriff, and the sheriff investigates. They may go to DCFS, and they do an investigation. And generally, if one of those investigations come out, yes, there is abuse, well, then the case pretty easily resolves itself without any problem, because, of course, no judge is going to give the abuser the child, and the visitation is going to be very restrictive in that. The problem comes out if both of those methods come and there's no finding of abuse by either the sheriff's department or DCFS. So then you have a case that the judge is going to have to hear. If they have money, the best thing the judge can do is appoint an attorney for the child, because that would, of course, help, because then the child has some voice in making the decisions. And if there's more money, that you can actually appoint mental health professionals to make some evaluations as to whether the parents were maybe truthful or not truthful, or exactly if there's abuse. But barring that, you have to go into court, bring witnesses. You can probably say what the witnesses are going to say before they get into court, because all of the abusers, the parent that's alleging abuse, they're going to all say, yes, that other parent abused the child. And of course, the person that is alleged to be the abuser, all of his family is going to come and say, never, this person would never do that. And then the judge is in a very hard and difficult decision, having listened to many witnesses, to have to craft a judgment that is fair to both parties, and always keeping in mind that what is the best interest of the child. I mean, it really shouldn't matter what happens to the parents. Really, we care about what happens to the best interest of the child. So it's a very difficult chore. I mean, it's a very, very difficult chore that the judge has if there is no support for the judge, and the judge has got to do it on basis of what is heard. To further complicate this, in many cases, one of the parents may be a self-represented litigant. So that parent doesn't have the benefit of having an attorney to help that parent through the judicial process. The other parent may have more resources and, of course, can't afford an attorney. So it's a self-represented litigant who thinks that their child has been abused. In the bottom of their heart, they truthfully think that this is what has happened, and they're having to go into a legal system without any legal knowledge or any legal help and present their case, and probably not presenting their case very good because they're not an attorney. They don't know the rules of evidence. They don't know the rules, that have to go through in court, and don't know the procedure that you're involved in. So I think that's what the judiciary is faced with in many situations. How could we help? Of course, if the legislature could pass that every child that says there's a sexual or physical abuse gets an attorney, I mean, that would help, of course. If we could have mental health professionals that would be available for the court to use without pay, I mean, because the parents probably can't afford it, but the state or somebody would actually be able to afford to pay for that. All of that would be tools that you do that. When I was on the bench, I used the tool, which I probably shouldn't use, and I hate, and I'm glad, and I'm not on the bench anymore because they can't throw me off, but I would pick up the phone and call. If I needed an attorney for the child, I would pick up the phone and call family law attorneys in the neighborhood and say, look, as a favor to me, would you represent this child? I mean, this is a difficult case. I'm scared there's something wrong with the child. As a favor to me, would you do it without pay? Pro bono, would you do it? And generally, they think, I was a young judge at the time, I may be there for a few years. Maybe I should, give the judge a favor and do this pro bono. And unfortunately, I even did that with mental health professionals. I called some doctors and say, I need some type of evaluation. I'm struggling here. I mean, I'm going. I don't want this child to go back to an abuser, but also I don't know if we have enough proof that they have an abuser. And one time, I lucked out in that I was worried, and I called a mental health professional, and he said, well, I'll be glad to talk to this person. And they called me after speaking to the person and says, Judge, do not allow this person to have visitation until we go further into that. And the next week, I read in the paper in East Baton Rouge Parish, the person was arrested for attempted murder. He was planning the murder of the mother of the child. So, thank God, that a mental health professional got involved, to stop that. But the judge, without help, is a judge that may have a history degree or may have a degree from college and went to law school and really does not have any training or very much training in that. I read the survey, and a lot of people said they need more training. And I was talking to Dean Landrieu. In the olden days, we used to have mandatory training. And maybe that's something that the Supreme Court may look at in the future, to have mandatory training where, that if you're going to handle family cases, that there would be some type of mandatory training. But I'm willing to answer any questions that you have. That's just my spin as a retired old judge on the big problem that y'all are facing, which is a massive problem to try to fix.
Thank you so much. Justice Holdridge, I think we have something in common in Ascension Parish. It's good to see you. It's been a long time.
Yes.
Thank you so very much for that testimony. So many things came to mind as you were speaking, and I thank God for judges like you who have served, who really had a heart of compassion and kind of went over and beyond as you served. One of the questions I guess I would have is, as it relates to, you kind of alluded to having those individuals who can provide different types of services. Is that a cost that can be actually picked up currently through the, a payment health professional funds? Can it be paid through funds through the courts?
I don't know of any funds that the court would have to do that. The courts,
It's one of the challenges.
yeah.
It's a big challenge.
Yeah, the court, you see, if the parties have funds, of course, you can make it. If one party has funds, you could probably make or order that party to do an evaluation. But of course, again, if you know a party is paying for the evaluation and the evaluation comes out in favor of the party that paid for it and against the party that didn't pay for it, the first thing that's going to be brought up is, well, of course, this party was paying for it. That's why the result was what it was.
Okay.
It would be great if each judicial district or most of the judicial districts with possibly help for funding from the state would be able to hire a mental health professional. I mean, that person would be on call. That they could give a report very quickly because time is of the essence in most of these matters. I mean, the longer you let it linger, the worse the problem gets. It doesn't get any better over time. It festers in both of the parents, and a quick resolution. And even I saw we need to try to move it where it gets to the Court of Appeals and they make a decision quicker. I mean, even though it's an expedited hearing, many times the court doesn't have the transcript quick enough, so it doesn't get to the Court of Appeals. All of those are problems I think we can work through. But having an attorney for the child and having a mental health professional are two things that I think would be a big assistance to the court system.
So currently we do in the juvenile court system,
In
right?
the juvenile court, yeah.
Right.
If you're in juvenile court, there's no problem.
Right.
But what we're talking about is.
There are problems.
Huh?
There are problems.
Yeah.
There are not no problems.
Different problem.
Different
problem,
problems,
yeah.
right.
But you see, and I preface it on if DCFS says there's a valid allegation of abuse, sexual or physical abuse, or if the sheriff's office says there's a valid thing and we're bringing a court case, that I don't know of any family court that is going to say, yes, I'm going to give the abuser custody of the child, or I'm going to give the abuser, unrestricted visitation with the child. When those things are in place, the court is kind of restricted about what they can do. But the bigger issue is what happens after they out of DCFS or after the district attorney decides that, no, this is not a valid, charge. We cannot prove this case beyond a reasonable doubt, which doesn't really mean that there wasn't any abuse. It just means that they can't prove their case. And that's what the district attorney, and I think we have a district attorney here, I mean, that's what they have to do. They can't take a case and charge a person and bring them all through a trial knowing that at the trial we're going to lose this case because we can't prove our case. I mean, that's just the way our system works.
Okay. You've said a whole lot. You talked about the training, which is something I think that we do need to revisit. And many of the judges did indicate that as well. One of the things that I repeatedly heard from some of the judges who actually did come and did speak, they talked about the information, the evidence that is presented to them. And that has really baffled me to some degree in terms of how we can make that process a lot more seamless, because it seemed like it may have been a breakdown in terms of actually what may have been actually given or the time by which they may have received it in terms of trying to make decisions.
I have that concern, but my concern is on the other side. The evidence rules in family court in the Code of Evidence, they say, are relaxed. And I don't know what that means. We have a Code of Evidence that in most cases, in all civil cases that comes before the court, you don't allow hearsay in. You don't allow documents that are not authenticated. You don't allow a lot of evidence to come in. In family court, it's relaxed, which in the Code of Evidence means that, yeah, they can allow stuff in. Well, that puts a great burden on the court as to what exactly are they going to allow in. are they going to allow all the hearsay in? So let anybody that wants to come in that didn't witness anything, but they heard something on the street, or now, which is even worse because of the fact that they see it through social media and on the Facebook and all these other things. Yeah, so they're now experts that this actually occurred, even though the only evidence that they had is they read it, on Facebook. So, that may be something that, even the Law Institute maybe needs to look at to see what kind of evidentiary standards should we have in family court? Should we have some actual standards? What can be admissible or not admissible in court?
And you bring up a very good point because
And just to make it a little bit more humorous, Dean Landrieu and I were at a seminar, and I was doing that, and she made an objection.
I was the trainer, he was the trainee.
And I was acting as a judge, and she said objection and all that, and I said, well, no, overrule. And she said, well, what are you talking about? That's clearly hearsay, double hearsay, triple hearsay, and all. I said, well, in the country, we want to know
We
this
just need to
information.
know. I call it the we need to know exception to the hearsay rule written by Judge
I
Holdridge.
said, we need to know what's going on in this situation. So.
Well, when you said you guys don't know, certainly if y'all don't know, we don't know, right? So then that clear, creates a real big issue and a big
The
problem.
balance, Senator, let me introduce myself for the record. Madeline Landrieu. I'm currently the Dean of Loyola University College of Law. I'm not here in that capacity. I'm here in my capacity as a retired judge at the request of really Judge Holdridge. And so I served on civil district court in Orleans Parish for 11 and a half years. For 3.5 of those, I was exclusively on a family court docket, which was at the time the highest volume family court docket in the state. The remaining of those years on the general civil docket, and then was on the Court of Appeal, on the Fourth Circuit Court of Appeal for 6 years before heading over to Loyola to serve as their dean. I also teach the collaborative law course. So the Collaborative Law Act that you all passed this year is a really important act to think about a way to think about our adversary system in family court better. So if I sue Toyota for a defective car, I never have to buy a Toyota ever again. If I sue my children's school for whatever they did to my children, I can take my children out of that school and go to another school. But if I sue my husband, who continues to be the father of my children, and we have to then, after we've ripped each other apart, as Judge Holdred has articulated, have to then co-parent. So it's a system that's built on an adversarial process that we probably should be rethinking about. And the collaborative divorce process is one way to rethink about that. So Louisiana's really made a great step to try to do that. And at Loyola, we are training lawyers to become collaborative divorce professionals. So we're happy to do that. LSU has looked into this. We're all trying to build a better rat trap, if you will, because the adversarial system in the family court system doesn't work so well. Even, I would say, for Judge Holdridge's point, even if he was an elected judge who was formerly a SANE nurse, went to nursing school, was a SANE nurse, and came with lots of experience in sexual abuse, the role of the judge still prevents you from, you can't see somebody for an hour and think that you understand the whole family dynamic, right? It's complicated. So what the relaxed rules that Judge Holdridge is talking about causes us to think intentionally about the balance between making sure we're getting reliable information as a judge, but not holding up barriers that are so tall that self-represented litigants can't get through the door, right? So that's the balance that a judge has to exercise every day, right? How can we assist in making sure we get the information we get? I think Judge Holdridge's point about having mental health evaluators available to families, particularly for low-income families, is really important. Because what we're trying to do is we're trying not to rip families apart. We're trying to help families heal. What we know about, and many of you all know that I've served as advisory counsel to DCFS for many years during the Governor Edwards administration. What we know is that kids want to be with their parents, even their parents that are less than perfect. right? Children want to be with their parents. So figuring out protective ways to make that happen is really important, and mental health professionals can help us. What mental health professionals say is this: as long as you're putting me on the stand to rip them apart, to tell you which one's better and which one's worse, I really don't want to do that. Because I'm spending my time in therapy with this family trying to get them to heal. And you're calling me to court asking me to take a side. That's why the collaborative divorce process is such a healthier process. And if we can figure out ways to fund that and figure out ways to bring that to life, that's really important. On the judicial education side, I served for, I don't know, Guy, for as long as I was a judge, as chair of the new judge training, right, to take judges through the new judge training process. It's a really robust process. I'm very proud of the Supreme Court and the work of the Judicial College in judicial training. Could we have more? Of course we could have more. Could we have more mandatory? Of course we could have more mandatory. The problem is judges across the state, for instance, in Judge Holdridge's jurisdiction, he was a general jurisdiction judge where he heard criminal cases, civil cases, family law cases, juvenile cases, right, probate cases, will, like everything. In several parishes, we have dedicated juvenile courts, and in some places, we have dedicated family courts. And so it's just the jurisdiction of judges about the amount of time that they can spend on these cases to get the expertise that they need to do this well and the support they need to do it well is challenging. But the issue of custody evaluators, mental health custody evaluators to support the work of family court judges is critically important and would be an area that the legislature could lean into funding. There could be we could think about, guidelines for poverty levels and, how you would think about who's eligible for that. But that would be a huge assistance. And I'm going to let Judge Balfour chat for a minute before we go into sort of the interrelationship between family court and DCFS.
And before we
and
do
how
that,
works.
Judge, we do not have a card for you. Okay.
We'll turn it in afterwards. Thank you, Senator Barrow. Yes, ma'am.
But before you go
Yeah,
any
I'm
further,
sorry.
because I do want to drill in a little bit further. You know, when you use the metaphor, I guess, talking about Toyota.
I didn't really mean to malign them.
No,
I'm
no,
sure
no,
they're a
no,
great
no, no,
company.
no, no,
I
no, no,
I
no,
love
no,
my
no, no,
Toyota.
No,
Do not intend to sue my Toyota. Right.
It's something more,
Right.
it is something more.
It's just an analogy.
Yeah, analogy. And I don't even want to say more definitive because what we're talking about is the lives of children that once impacted, oftentimes, even with all of the therapy, can never really be recorrected. So I understood you using that metaphor analogy, but this to me is so very different. And I wanted to, first of all, kind of point that out. Then first of all, I want to thank you so much, my very good friend. Been knowing you for a very good long time. I am going to just push in a little bit more about the funding because I do want to delve into this, and I didn't have a chance to look at the budget of the judicial branch, but I will go back and look at that because I know that there is a judicial expense fund, right? And I'm trying to see how can that assist us
Sure.
in assisting those families, right? How can we utilize some of that funding to help? And then Rule 23 of the Supreme Court allows that there could be judges appointed to children, especially in sync cases. Do y'all know if that is happening at all or has happened? Did it happen when either of you served in your capacity? Did y'all ever?
I never requested of the court an ad hoc judge to sit for me on my cases because I was able to manage. But yes, it does happen, right, where judges can be appointed. The Supreme Court has the authority to appoint a judge to come in and sit on any case where the court thinks that appointment is necessary to achieve justice for that family.
But remember, the judges also, under the Code of Judicial Conduct, have an obligation to sit. Mm-hmm. So it's your obligation as a judge to sit and
To hear difficult cases.
And that's what is the worry about if you allow judges to get off when a difficult case comes. What will happen is some judges will never hear the difficult case. They'll get off. And who will be hearing it is the other judges on their bench who will be thrown into these, really difficult cases. And I ran into that a little bit when I was on the 23rd, because I would tell the judges, listen, I don't mind taking a difficult custody case, but don't give it to me after you've messed it all up. Give it to me at the beginning, and I'll make my own mistakes, but don't, start and then bring in another judge, because the other judge won't know what, that you may have known. So it's a difficult, I understand about getting ad hocs and all that, but
It's not ideal.
it's not the best solution, I wouldn't think.
And so we've heard a lot of that as well. I was trying not to get into too much of this until all of you guys had a chance to speak as it relates to the recusal in that whole process, because we've heard so many horror stories as it relates to that as well. So I'm going to just pause and just kind of be quiet, and then I'm going to hear from you, Judge Balfour, and then we'll go from there.
Thank you, Senator Barrow. My name is Kelly Balfour. I was a judge on the 19th JDC for a number of years. I also practiced family law some before I took the bench. I'm now on the First Circuit Court of Appeal. I would like to follow up some on what the dean and judge were saying earlier about the need, and really what you need from having lawyers appointed on behalf of the child as well as mental health professionals. And Senator, you were mentioning earlier about whether or not the Judicial Expense Fund could be utilized, but always remember that our district courts are funded at the local level. So each of our courts have a different funding stream for their local needs. And so they would prepare their budgets and go to either their city council, to their parish government, to their levy boards, whatever their parish, or if it's a multi-parish jurisdiction, you might have more than one funding opportunity for them. And each of those areas can highlight or say that they would prioritize certain things. And also the problem from the Judicial Expense Fund is what you were mentioning, is those are self-generated. So if you're in one of the poorer areas, your JEF fund isn't as robust as some of the other areas that have higher volumes. And so you're still tasking them to pay for these individuals, these attorneys, these mental health experts at the local level for agencies that do not have the funds there. So if an opportunity for the state to be able to step in and offer some support, as the dean was suggesting, that possibly you set a standard, how much they make, who is eligible, almost like a pauper form that you do for there. Additionally, from the other point, and I don't want to touch on everything, but you mentioned something about the evidentiary rules. From the Court of Appeal standpoint, I know that Judge Holdridge mentioned that we like to utilize that everything that comes to our court that deals with these are set on an expedited manner. So as they come to us, we try to get them as quickly as possible. However, we only can rule upon the record that is before us. And again, if it takes 2-3 weeks to get the record to us, there's really nothing that we can do. We can send some strongly worded letters. Y'all are ordered, give me the record. But it's still up to the local clerk and their offices to put that together. It's up to the local court reporter to transcribe what happened in that particular case and get it to the court so that we can then put it on our docket and then start that process in an expedited manner. And so there are some steps that can be kind of focused on to make sure that the matter can move as quickly as possible. Because again, for the best interest of the child, you don't want to have a decision that's kind of pending in the air that needs to have some type of review that can last 3 weeks, 4 weeks, 6 weeks, 8 weeks. You'd like to have that supervisory review as quickly as possible. So those are the little areas that I think that we can focus on that can help, along with many others.
Okay, so I'm going to go back to the fund
Yes, ma'am.
again. So the judicial fund that is set up by each judiciary has a fund created statutorily, correct? Am I right about that?
They're all allowed to have them. I'm not sure everybody has them.
Okay, so, and you said that they set up their own budget based on what? So when you say that, is there like particular needs that judicial court would like to handle or
So
address?
from my experience at the 19th JDC, we prepared our budget, submitted it to the city parish, and the
Okay.
mayor president through the board would look through and either approve or disapprove. If we needed to hire a local mental health professional, not to say local, one to bring in-house maybe. So some of the other bigger parishes or the bigger JDCs that might have the funds may be able to do that, but then you're still dealing with the child that are living in different parishes, different parts of the state. now have different services that are available to them, and that's not very fair. If you have a child that lives here in East Baton Rouge Parish and then one that potentially lives 5 miles away in West Baton Rouge Parish, in the 18th JDC might not have the resources that the 19th does. And then so you have a disparity between the children, and the idea of maybe potentially having some legislative insight or intervention to have a fund that would be able to be tapped so that all children have the same resources might be something that could be beneficial.
Okay, and I'm really hearing you loud and clearly, but I'm gonna go back to this. So each judicial court can have a fund.
Yeah, but the fund is from court filings.
Fees.
And fees and stuff like that. So, yes, if you have an interstate running through your area, or if you, in a very populated area, you probably have some money in a fund. In North and Central Louisiana, many of those judicial districts, some of those judicial districts are one parish with maybe 10,000 people in it. Their judicial expense fund, they don't even have enough money generally to come to a seminar, because there's not any money in the judicial expense fund. And unfortunately, most of those parishes are poorer parishes, so they can't go to their police jury or parish government to get money. So they may, everything in their budget, they may need to pay either a secretary to help pay for a secretary or pay for some other funds. So each, unfortunately, like our whole judicial system, each judicial district operates differently.
Yes.
And some of them have funds, some of them have no funds at all. And that's a problem that you would have. So the judge that's in a poorer parish, has no ability to hire an attorney or do anything out of their fund, even if they wanted to, because there's no money in the fund.
I get it. So I understand where some areas, because of, disparities, the lack of income, et cetera, exists. And we want to make sure that we have fair and parity across the whole state. I get that part. But I still want to go back to something that you said, Judge Balfour, as it relates to the budget that each one creates. So they create a budget based on what?
Well, my perspective is they create a budget on the needs of their area.
Of their area, okay. And so that may be, so if some of them may want to address maybe drug courts, as I'm going to use that as an example.
Yes, ma'am. I didn't mean to speak over you, but they would then go to their budgeting authority and say, this is what we would like to accomplish. Can you please appropriate the funds? And then if the funds are appropriated, then the court, again, I didn't want to single out one court. All of them try their best with all the resources they have, but some, just by the virtue of where they are, just have limited resources.
I understand. So along those lines, have any court made any recommendation to actually have the appointment for children as a part of their budget? Do y'all know?
I am not aware, because I'm not aware
Okay.
that there's any lawyer who is appointed by a court to serve as counsel for children in a courthouse, because it's really hard. So for instance, in our pro bono world,
Or the mental health.
or the mental health professionals, some courts have hearing officers and work through hearing officers who have a little bit more. They do that exclusively, and so there's a little bit more there. But the mental health expert, for instance, we had some money in civil district court for a while to hire a domestic violence expert, right, who was there to assist litigants through the domestic violence process. That was some VAWA money that was used. I think courts are getting creative about this. But I would say that it would be almost an impossible task from mental health. I don't know of any mental health professional who would take the job of saying, I will come work for civil district court and be your mental health evaluator for all of your cases. It's just the volume's just too great.
Yeah.
The volume's too great, right? So I'm just not sure but having a source of funds that a judge in a high conflict case could access to appoint a qualified mental health professional. And there's only a small amount of cases that, this is not like every case doesn't need this, right? But on the high conflict cases where a mental health professional would be in order, Then there used to be, New Orleans used to have lots of resources that did this, and those resources have dried up. And of course, to Judge Balfour's point, the poorer the parish, the fewer resources they have, even outside of the court, to service the needs of the family, right? So
And
it's sort
Senator
of
Barrett, I just want to say, if there's no abuse and they have two good parents and everybody's got resources, the judge can't make a mistake because it doesn't matter which parent the judge gives it to. The parent loves the children, both parents love the children are going to flourish and it's going to be good. I mean, it's the situations where both parents may need, assistance or one parent needs assistance and that's where you kind of run into the problem. And I just know from speaking to family court judges and people who do this, they're having an extreme problem trying to get mental health professionals to come into court and testify. That
don't wanna
there
do
is
it.
there's no resources even out there for people that can actually afford them to try to go and get a mental health professional that would want to come in an abuse case to testify, in court. They say they have, a lot of problem do that. Maybe some of the mental health professionals here could help us, but that's what I'm hearing, and that's hearsay. I don't know that for a fact because, I've been on the Court of Appeals.
Okay. I'm going to keep beating the same horse.
Yeah.
Because I hear each of you very loud and clearly, and I want y'all to hear me really loud and clearly as it relates to the emphasis being placed on any court making this a priority. So it sounds like it may not have happened. It sounds like to me maybe that has not happened. Maybe that has never been a line item in anybody's budget in terms of trying to provide that service. I know that it may be tough to get, but I don't know if there has been, don't sound like a concerted effort to address this segment that we know is very fragile. And I think I can hear you guys say it is broken. It doesn't work very well. So that's what I'm really trying to get y'all to hear. Yeah, because that part really bothers me. So I want to see how we can begin to address that part. And it may require that the state have to also put up some funds, but it seems like there may also be another gateway where we can actually address that through what you currently receive as well. Maybe it can be a joint effort in those areas that can afford it. And that would be a conversation we can have later to figure out like what that looks like.
Conversation, Senator.
Yes. Okay. Miss Moody.
Thank you so much. Thank you, judges, for being here. So I'm State Director for Court Appointed Special Advocates and work very closely with the Child Ombudsman Office. And my office probably gets 2 to 3 calls a month requesting a CASA on family court cases. And of course, we have to explain that we can only serve SYNC cases. But we've had some discussion lately about reevaluating the model here within the state, reevaluating the statute, and perhaps looking at the potential of having CASA on very specific family court cases where there are, severe allegations of sex abuse or child abuse or something like that. So I'm curious from your perspective of what you would think or support in terms of having.
I started CASA in the 23rd, so I'm a big supporter of CASA. In this situation with abuse and child, any resource that we have is better than none. So I would welcome CASA if we can have someone else involved. Their role is going to have to be delineated very, carefully, maybe even by legislation. I'm not sure, but I as a judge, I would take any help that I could get. So if a CASA person could go out and go to the person's home and have where the child could call the CASA person if there's something that would make me feel a little better that there was another person involved, that they didn't have to call the parent, they could call CASA, and maybe then CASA could inform the court of some dangerous situation or some bad situation. So I would be all for it.
I agree. I think it comes down to, again, so when CASA was founded, right, the reason CASA and Judge Muley and Judge Gray, you know, all the folks who were around at the beginning of CASA, which is court-appointed special advocates for children. They're volunteers who are specially trained to become the voice for the child. They're not a lawyer for the child. And let me just make sure that everybody here understands that. A lawyer is required to basically do what the client wants. The client directs the lawyer to do the work. That gets harder and harder the younger the client is. And harder when it's a 13-year-old client who thinks they know what they want but don't really know what they want, right? That in and of itself is complicated. But a CASA has a different role, and a CASA is the voice for the child in court. CASA didn't expand into the family court area because it was just too big a thing.
Correct.
That's why. It wasn't we can't. It was just too big a thing. And so it got its legs in the juvenile court space where it could better sort of, but now that CASA is as strong as it is, both in Louisiana and nationally, so congratulations to you for the really fabulous work. Having a CASA on complicated family court cases could really, really help the court,
And
in my opinion. I mean, this is my opinion.
Yeah, I would
don't
echo
want my-
that sentiment. I wouldn't see a scenario where the court would not welcome some involvement as long as, you know, it's allowable by statute and all the good things y'all do on behalf of
And
children.
I'll say even, what you said, Judge, just reminded me, I had a conversation with a judge with juvenile jurisdiction who did not have a CASA in their court system. And we were trying to bring a CASA there, and the judge said, never mind, it doesn't matter in this case because the child's only 2. And what I had to do was spend time with that judge talking about the impact of a 2-year-old living in conflict, right? So that was many years ago, but we've learned a lot more now about the impact of early adverse childhood experiences and how very, very young children need to be freed of conflict, right? And of the harm that comes from conflict. So even what I would say is not to limit it to teenage kids, right? Like really young babies, young children who are engaged in conflict perhaps need it the most. So I would, again, be supportive of the CASA if you all had capacity, and we'd have to think hard about
and that's, yeah,
how to
that's
expand
the
your capacity to
challenge.
meet the need.
Yeah, we definitely don't want to open up Pandora's box, and I don't want my network coming for me saying, "What are you doing right now?" Because it is a challenge. I mean, we struggle to recruit volunteers statewide for the cases that we have, but we do understand that there are very specific cases where if a CASA, if an advocate for the child was involved, it could help the judge make those very hard decisions.
So my suggestion to you, just as I sit here off the cuff, would be to think about how to pilot that in 1 or 2
That's what I was
courts
thinking.
with 2 really good judges who are committed to that, right? And pilot how that might work and what that might look like. Maybe it's 4, maybe it's 5, I don't know. But thinking about piloting it before you expand
And
it so that you could then adjust your
Know the
training,
resources, right.
to adjust your training to the actuality of what the CASAs would be engaged with.
And you're going to probably have to have legislation because
You would.
unlike in a sink case, in a custody case, if you get involved, your CASA workers are going to get sued. Let's be very frank. Unless there's some immunity or something, that CASA worker is going to get sued by the person that doesn't agree with what the CASA worker is saying.
I think that's a very good perspective and good information.
Institute could look at that.
Okay, I see my sister in good has arrived. Senator Mizell, how you doing?
Good T-shirts, girl.
Yeah, that's right. That's right.
That's right. Thank you.
Thank you
my
so
friend.
much
Thank
for-
you for letting me sit. I appreciate the kindness of the members to let me sit in on this because you've done some tremendous work. God bless you.
No, we have done tremendous work.
And I may have missed. I see my good friend there. I may have missed. This may have already come up because I walked in on the need for mental health, which I can be in any meeting all over the place, and it always comes back to mental health. And that, I totally agree. But until we reach nirvana, where we can have the mental health and we could have CASAs in every court, and you all may have discussed this, but what training is being done by the judges specific to child well-being and handling cases, what training is required right now?
So, well, the only required training right now in the judiciary is the mandatory new judge training when a judge is originally appointed, and it is covered in that training. We cover trauma-informed judging, right? We cover, I'm sure that all of you have heard of the ACE study, the Adverse Childhood Experiences study, and the impact, and so that is covered. Whether it's robust enough, whether it's enough, right? You would need weeks for it to be enough, right? You would need weeks and weeks of training. But like doctors spend, years, trying to understand this. So there is training, and then there's also training offered, often, say that twice, right? There's training available to judges in this work. It's just a matter of time and time off of the bench, to go to a training, like to shut your courtroom down, to go to a training, all that's challenging, but the training is there. There's online training, there's lots of robust training that is available to judges who seek it
In
and who
person?
understand the
Is it
need.
in person?
In person and in person, yes.
Do you-
And we should be doing more of it.
And I don't live anywhere near the life of a judge, so I'm not sure, but I was listening to the Supreme Court on the way here, so I feel like I know a lot
There
more
you go,
than I
look at
did
you,
an hour
look at you.
It's kind of like
Yeah,
staying
yeah.
at Holiday Inn last
Yeah,
night.
I understand.
But is there reflection? Is there an opportunity for a judge to know, well, this case is called some outrage. This case is really not a precedent we want to set in Louisiana. And the other judges look at it and think, maybe we could do better. Is there a moment of reflection
Yes.
among?
Yes, one of the reasons that the Supreme Court has supported judge-only training, where only judges are in the room, is to allow for that
Right,
reflection.
Right.
Right? To allow for that deep dive into cases, deep dive into issues, and just to allow judges to really learn without lawyers being in the room or legislators being, without judgment, right? To really, as all of us are better tomorrow, I hope, at our jobs than we were yesterday. So we do that. We are also, just in my capacity as Dean at Loyola, we have just been given a gift from the Bar Foundation to represent children in need of care in juvenile court. And in connection with that gift and grant, I have dedicated some of that funding for judicial training on these issues, because there's a need for more of it.
So is it mandatory? 'Cause I
It is
think
not.
that's the-
I can't,
yeah, and see,
I don't have that
and
kind of
that's-
power,
I know,
Senator.
I
Senator
Hands are all
Mizell,
tied.
you weren't here probably when I said,
He
I
wants-
suggested that we probably need
Should mandate.
mandatory training. We used to, years ago, have mandatory training on
Right.
some issues, and it's hard, and when you say mandatory training on a family matter, it's going to be hard because, of course, you have some judges that's all they do is family. But like where I was, I had to do criminal, civil, that. So to take 3 or 4 days just to be mandatory training on family would be a burden for some of the judges. But I think, it's necessary in some cases, and, I think y'all could say to the Supreme Court, I'm sure the Supreme Court's listening right now, that maybe that would be something that they need to delve into and look into the Judicial College could look in also.
And
I also-
Senator, if you had, and I'll be brief, is just this past year, the Supreme Court just ordered an extra hour of mandatory just domestic violence training for all judges throughout the state. That's on top of the other training that we do. And I believe that might have been passed this past session, and or a suggestion to the Supreme Court in a resolution. However, it came about, the Supreme Court did order that for all of our judiciary, and we just had our first hour this past fall conference just 2 weeks ago. So
And that was a focus on the trauma-informed
Correct.
handling of that case, right?
Exactly, and that's on the domestic violence portion of it. But from this standpoint, from the child, I think it would easily dovetail into that if that's what this panel, the Supreme Court and the legislature would like to recommend.
I also just want to say that one of the things that is my hope for the legislature and for our state, for the legislature, for the judiciary, everybody looking at this, is to understand that families don't enter the family court system or the juvenile court system or the criminal system. Sometimes they're in all of them, right? Sometimes a complex family dynamic is in all of our systems. And so while judges think about our jurisdiction and what I'm responsible for, there is cross-jurisdictional learning to be done about the trauma that impacts families that cause them to come into court. So I do want to sort of step back a minute and recognize that many, many, many families go through a divorce proceeding and never see the inside of a courtroom but to get their judgment signed, right? They solve their problem around the kitchen table. It's not that it's easy. It's not that there wasn't a lot of pain. It's not that there wasn't a lot of sense of failure and, all of that when it comes to a disruptive family. But many resolve their cases, right, before they ever get to a court. Maybe around their conference room kitchen table, maybe around their lawyer's conference room table, maybe around the judge's conference room table. Those that get to court in the adversarial process are complicated, and they get there because they're complicated for a reason, which makes the resolutions more hard to get at, if that makes sense. So, but understanding family dynamics, understanding trauma, understanding how that works, understanding mental health is something every judge should be trained on as much as we can possibly be trained on.
I'll have a follow-up question to that. Was that all, Senator? ACEs, because this is something that has come up recently within the last decade or less,
Yes.
right? Do y'all believe that every judge has actually gone through ACEs training?
It would be my dream.
So at this point,
Right. So, I don't know if I can answer that question. To me, every judge should understand both the study that was originally done, Dr. Anda and Dr. Filitti's study, and the expanded ACEs that came out of Philadelphia many years later on the community-based ACEs, and understand the impact of that work on the people that come to our courtrooms. And if we're not understanding that, we're missing something. So that is a really important component of judicial education and, quite frankly, of legal education. So I'm now teaching that at our law school because I don't want anybody, I haven't made it mandatory for every law student to get it, but we're working on understanding the impact of that. And quite frankly, every policy in the world should be adjusted according to that study because it's really important work, right? But we should all be doing more of that work and understanding the impact of trauma on those who come before us in any capacity.
So just kind of following up on that, when I look at question number 9 that's on the survey, and it asks about the specialized training, and we have about 70% of those who participated rather, said that they have had some training, but not actually outlining what that may actually kind of entails. Only less than 10% said extensive, and then more than 30% said no training. That is extremely concerning.
Should be.
And
Should be.
Because you're making decisions that are really life altering, right?
Sure.
And for that was very troubling for me when I saw that. So when you said that you're offering training, I just want to go back to make sure that I understood. A lot of times, this is upon the judge's discretion to attend, which, with all of the constraints, probably is not as happening as often as we would like.
Correct.
And Senator Barrow, there's a certain amount that's required, all right? Certain judges in certain areas of the state cannot get any more training than that because they don't have the resources to go to attend any more training because their judicial expense fund does not have enough money that allows them to go get any additional training. I think some people are under the guise that judges have unlimited, they can go anywhere and travel anywhere and all that. That's really not the case in a lot of areas in the state. Now, there are some areas, yes, they have St. Tammany Parish, has probably a large judicial expense fund. Ascension Parish, everybody, but I mean, there's some places that probably have where if there's some training and the judge wants that training, that judge can go and get that training. But there's some areas that,
But that's a problem.
it is a problem. It's a judicial education problem. There's no doubt. And we're trying to fund that. You just passed a new bill, but, Judicial College a long time ago, Judge Landrieu and I where we passed for 50 cents on for judicial education, where everything passed, and just this session, they bumped it up to $2.50, but it all doesn't go to judicial education. Some of it goes, an additional amount will go to judicial education, some goes to the court. But I mean, it is a problem, and I was shocked, as you were shocked, when with 30 or 40% of the people said they get very little training.
No, they say no.
None.
No education,
Yeah, yeah.
no training. That
That's-
is extremely, we should all be concerned about that.
I agree.
So the question is the training available and they're not going, or are they not going? Right, like, so, in other words, that's really the
So
question,
both,
right?
yeah,
Both.
so, yes.
So, the Judicial College, which I chaired and Judge Holdren chaired, we both served on that board for many times, we ended up designing training and taking the training around the state. Because if judges can't leave their bench to go to New Orleans to spend 2 days to go back, right? So we would take training to them, and the Judicial College can do that and should be doing that, right? So the Judicial College should be developing a training and taking that training, right, around the state to the various courts of appeal. You can go do it in the 5 courts of appeal, right? And the judges in those districts can come. So there are ways to make the training more available and more readily available, because remember, they've got the balance of getting off of their docket for the day. When families are saying, why aren't you on the docket? And they're like, well, I'm in training. It's like, but you should be on the docket. So there's that sort of respect for understanding the need for training and the limited amount of time that judges have, but there's no reason for judges to have no training
And I'll hop
in
in.
this important area.
And I apologize, I'll hop in as of now, I'm on the Judicial College Board currently, so as my 2 colleagues here have retired. We do still travel the state. We'll do a spring, we'll do a rural conference that are in certain parts of the state. We'll bring it up north. We'll do Lake Charles, Natchitoches, Shreveport. So not everything is in New Orleans, which is a large ask for judges that are in Monroe and Ruston and Shreveport to make their way down there. So travel, and it is part of our goal is to continue to offer these classes at each of our training experiences, because there's a whole lot of things we go through, from recent updates of evidence and things, and so we try to make sure that there is a class offered for all judges for all their needs for their particular benches.
So for this year, how many classes or how many programs or classes or trainings have y'all done throughout the state? Because this is
for-
October.
For the 2025, so we'll do the spring college, we'll do the summer school. There's one that's 1, 2, 3, 4, 5, probably 7 to 8.
So this year you have already done 8, or you will do 8?
Two more in December.
Okay.
And then we'll start a whole nother round beginning 2026. And then with the making sure the domestic violence portion is available for each of these, for those judges that need the new requirement. And as Senator Mizell was indicating, this is whether this should be mandatory from the Supreme Court or not. It certainly should be taken by all judges that have these cases before them on their general dockets.
Senator Barrow, they do, and I think it's August, have a family and juvenile conference. It's
Specific conference.
Specific for family and juvenile court judges.
And they've had that already for 2025?
Every year
Every year.
in August.
It
Okay.
is every year. And my guess is for those individuals that replied to the survey that y'all have, those that have a very heavy family court docket, make sure that they attend that particular conference. And those that might not have as heavy of a docket, but might have a case here or there, might not have attended that specific conference. But there are a number of conferences that are available.
So the Judicial College is traveling throughout the state.
Yes, ma'am.
And by the end of this year, they will have had 8 trainings.
At least.
At least. And some of those are required, right? Some of them are required, or all of these? Just one?
Just one, the domestic abuse is the only mandatory training. The rest, you can choose to go to one of these 8. You can choose to go to another conference. I mean, the only, you have to get, I think, 15 or 16 hours of legal education, CLE, per year.
Okay.
But
That's
ethics
something
and
we should look
professionals.
at.
Yeah.
Okay. All right, thank you. Ms. Wascom?
I'll make this quick. Thank you. Because several people have asked the questions I was going to ask, but I do have a question. How long is the new judge training?
We just had a debate about that. So, we were just together in a judicial college meeting. The new judge training for next year, because it is an election year in which more new judges are elected than in the intervening years. So historically, in the intervening years when terms are not up, every district court judge is up at the same time for election. So next year, it's going to be between 3 and 5, it's going to be 5 days.
Okay.
The question is whether it's going to be 3 and then 2 later, or like we're debating about how to properly deliver that training, but it should be a 5-day.
But it's like a set curriculum, I guess is my question.
It is a set curriculum
Okay.
that is being set as we speak, right? And the priorities about what to include and what not to include is a subject of a lot of debate among judges.
And then on top of that, there are follow-ups at least once every other month. That is we try to still get the new judges together, knowing that it is a hard ask, again, for everyone to come in person, but those follow-ups are via Zoom, so they can get together, talk about what's going on in their benches. So the new judge training continues past that for the in-person training that Dean Landry was just speaking about.
And Ms. Wascom,
Yeah.
in my opinion, there's not enough time
There's
for new
not.
judge training.
Oh,
It could
I
be,
believe-
because you get people that are elected judges, especially in a general jurisdiction area, that maybe only handle civil and then are thrown in as a judge and has to handle civil, criminal, juvenile, family, every kind of case. And it takes and I was one, I know for many months before I took the bench and after I took the bench, I studied constantly because it's impossible to know just a little bit about each of the subjects that may come before you.
Right. I guess that's my other question about the CLEs. The only hour that's required is the domestic violence portion.
Isn't there a trauma-informed hour? Didn't y'all pass something? Somebody else can help me with this, right? But there is, yes, and then you have to attend the mandatory new judge training. What I will say is that many judges take advantage of the education opportunities available to them, because there is nothing more frustrating to experience as a judge than having to make a hard decision about something you don't know enough about. So I don't want to take that lightly. Judges don't want to be on the bench and be uninformed about what they're doing. That makes for a miserable day as a human being. So most judges seek out the training they need to do their job well. And the training is available for them to get it, because it's particularly in the family law case, nobody wants that on their shoulders, that you're making a decision without proper, education and experience and rights. So it's not like anybody just says, oh, I don't care that I don't know anything else. I'm happy to just do this, and it doesn't matter to me what I'm doing, right? That is not the perspective that judges take, and the public, every once in a while we get it wrong, right? But for the most part, the public is smart, and they elect people who they know are dedicated to the work that is here for them. So most judges want to take advantage of. We also, in the judiciary, have a very strong mentoring program where judges have a judicial mentor who's sitting on the bench that they can pick up the phone and call at any time and say, I have this really tough thing going on. Can you assist me? So we provide within the judiciary a lot of support for judges who are senior judges, like even everybody. Nobody knows all of this, right? This is a lot of information. So we do have a very strong judicial college program that the court is very proud of, that we're very proud of. Can it be better? Sure, more, right, of course. And a strong mentoring program to support judges in this important work.
So I have two follow-up, and they're very short. One is, y'all mentioned the Zoom. How much of this could be, like, for the continuing education, could be sent to some of these judges in the rural parishes that don't have the opportunity to go to the judicial college? Is there an opportunity for them to see, like, taped education?
Yes, there is, and building the content for that is important.
Okay.
But yes, they certainly can.
Okay, and then I have one, I just feel like I'm not sure that the public understands this, so if one of y'all could answer, just so it's on the record. If there's a custody case and it's 50-50, and it's in two different parishes, how do y'all decide which parish the case is heard in? Is it the custodial parent? I just want to make sure, because I don't think this is something that people understand.
think under the Civil Code of Civil Procedure, the first filed case is where the case is going to be heard.
Okay.
So whoever files, if the parties live in two different areas, now the only proper venue to file a family law case is where either the parties are domiciled or the last matrimonial domicile. So those are the only three places that a divorce case or a custody case could be filed, in one of those. And generally, it's the first file, so whoever files it first.
Okay.
That's where it's going to go to that area.
I just wanted to make sure, because I think that's one of those things that people don't really understand.
We ask that in law school questions, in law school exams, too. It's important to know.
Thank you, Ms. Wascom. Honorable Guillory.
Good morning.
Good morning.
Did you have?
Welcome.
Thank you. No. I was going to reiterate what the judges had said. We do have specialized training. There's mandatory training that we attend. I'm a new judge, 5 years. And the new judge training was absolutely amazing. And unfortunately, when I was elected, it was right around COVID. So we had to do it via Zoom, so we didn't have that interaction with each other. However, we were able to get together later as a group and able to exchange ideas. My particular division is strictly family and juvenile court in Calcasieu Parish, which is the 14th JDC. The beauty of my job is I have some wonderful colleagues. When there is a problem, I can approach them and say, sometimes I tend to have tunnel vision. Let me just lay it out for you and give me your thoughts. And that is the beauty of having colleagues that are available. And secondly, the mentor program is amazing, because when I first got on the bench, I had a homicide. My first week on the bench, a homicide involving 15-year-olds. And I was able to pick up the phone and call my mentor judge and tell her this is what's going on, and she kind of walked me through it and gave me some excellent suggestions. So I had practiced family law before I became a judge, and I was also an ADA, so I had that advantage. And I'm attending the family law seminar tomorrow at LSU. So there are additional opportunities aside from the Judicial College that we can get educated and stay abreast of the ever-changing laws.
So all of those trainings that you are referring to, they are not mandatory. These are just classes that you decided to take?
Well, as you know, pursuant to our Louisiana Bar Association, we have to take 15 hours. We have to have ethics. We have to have professionalism. We have to have sexual harassment training. Those are mandatory. This mandatory DV now, and also trauma-informed training. So we have our summer school for judges and lawyers, where we have the 15 hours as well as the required mandatory hours offered. There's also fall conference, there's also spring conference. There's also, we have an association just of family and juvenile judges where we get together and meet and have trainings. So training opportunities are available to us. Could there be more? Yes. It is difficult to leave your bench and go to a training. Today, I have one of my colleagues standing in for me, and I have a 10-page docket. I had an adoption at 8:30, and then I had motion hour for divorces at 9. So I owe him big.
He's
But I
doing you a
felt
solid.
It was important. It was important for me to be here today.
And we thank you. We thank you for being
Thank you
here.
for having me. But again, you work around, you work together, you support each other, and you say, I'd like to go to this training. And all my years of practicing, I was in ADA and still handling private cases and was not able to go to the family law training. This will be my first time going in over 30 years of practicing law. So I'm really excited about that. But we had the individualized training around the state that we could attend. So, it's available. Could we have more? Yes, I agree with my learned, esteemed colleagues.
So you list all of the mandatory trainings that you have to have, but the training that you're having tomorrow is not mandatory.
Not mandatory.
So
no.
it is a training that you have decided to attend.
Yes, ma'am. Family
So
law.
yeah, so and I guess that's what I'm trying to get to, and that's what I would like to see. I would like to see, to some degree, some kind of rubric that shows us, and I think that this actual survey really outlines it pretty well when we have more than 30% of the judges who have had no training. Right, so they have the mandatory training. So I'm assuming that when they say no training, that does not include the mandatory training. But that is very disturbing, and so I would like to see that level of rubric in terms of individuals who are going over beyond, like you are, to get the additional training because it means that much more to you.
And I don't know, Senator, if there was the no training specifically on child sexual abuse as opposed to no training at all, because we're required to be trained.
Right, I think the answer to that question is no. I'm guessing.
Yeah.
I don't mean to interrupt you,
No.
Judge, but I think I'm guessing that the answer is no training specifically on child sexual abuse. Is that answer to that is the answer to that question? When
Like
that judge
specialized
said,
training.
right,
Yeah.
specialized training on child sexual abuse.
Well, it doesn't say all of that, but it just says specialized training. But again, I think that it can go to that, right? But at the end of the day, it still is a huge bucket of individuals who may be seeing these cases who have no knowledge or have not had any training in that area.
Yes, sir. Yes.
Okay. But thank you so much, and thank you so much for being here. We greatly appreciate you making the time to be here and to learn more and to actually lean in and to give us more information as well. Dr. Birch. Yeah, that's right.
Sure, thank you. So you guys have touched on timelines of investigations and how they line up with the judicial process, and also just access to information from like a DCFS investigation, law enforcement investigation. As a committee, we've talked a lot about ways to address barriers to communication or bureaucratic barriers that may get in the way. Are there things in your judicial experience in family court that you could see folks on this committee having a role in helping to better promote collaboration or to increase access to the information that's needed to make thorough decisions in family court decisions where you may need information from DCFS, law enforcement, things like that? And I have a second question, but it's unrelated, so I will save that one.
So I'll take a shot at this. I do think that the various agencies, law enforcement, DCFS, whoever you might think about, all have their own rules of confidentiality. And the cross-sharing of information among people who think they have confidentiality with each. So what I would ask is, who are we protecting the information from? Right, so looking at the respective confidentiality rules of the various agencies, I think would be a really good role for this committee to think about, right? So if DCFS has information and they say it's confidential, I can't share it with law enforcement, well then who are you sharing it with, or how can you, and what's that barrier? If DCFS says, yes, we have a case where we've had a child, but we invalidated the case, but we can't share our file with the family court judge, what is that, who is that protecting, and should we be doing that? So I think this, one of the suggestions that I might have for this committee and its work, and of course I know this goes to the staff, right, to think about is what are those various rules of confidentiality, and can we find ways to continue the protective elements of confidentiality, which is why the rule's there in the first place, but look at the rule with an eye towards information sharing across agencies so you're not duplicating work.
Fantastic. My second question, I am a mental health provider and I work in the family court system very frequently. And I've worked in other states besides Louisiana. And so, I can kind of draw from my own experience, which is 3 data points, which is not super broad, but, having been in states where things like privilege attorneys exist and they help represent who has access to treatment records and whether or not they're relevant for court, things like that are incredibly useful. But I think my experience in Louisiana is that mental health is mental health is mental health. And so a child's treatment provider often gets called into court. And despite my ethical guidelines from the APA that say I'm not supposed to be in a dual relationship with my client, therefore I can't be both a treatment provider and a neutral evaluator. But oftentimes the clinicians that I supervise within my agency get called into court and get asked to weigh in on custody decisions. And I think just as we think about as a body, what are the protections and guidelines that we have? I spend a lot of time, and our agency spends a lot of money hiring attorneys to make sure that we can respond to subpoenas and have adequate representation in that process. And it is a heavy resource drain. And it is, I think, a lot of mental health providers don't step into that space in that arena or just won't take those cases altogether for fear that it will be a drain on their, if they're private practitioners, on their ability to earn income because they're being called into court and things like that. And so are there states that you look to and say, here's a state that's doing it well, whether it's the funding or the structure? Are there places to look to that, like, here's a model that's working particularly well?
I think that's something that needs to be studied.
Yeah.
And you're hitting on one of the biggest problems that you have in family court. And just let me tell you from a judge's perspective, you have all of this information. I have no other information.
Right.
And you can give me at least much more information than I have. And I don't want to make a bad mistake about this child.
Right.
And you have that information, and you're not supposed to give it to me. And I'm going to subpoena you and threaten you and do everything because
Oh, yes.
you're the
I know.
only, you have the only information that I have. And
Yes.
I'm desperate because
Yeah.
I would like to do a good job. But I can't do it because there is nobody else other than you. But you
Right.
only were a counselor and you did not make an evaluation and you don't want to come in and tell us anything, even though you have knowledge, but your standards prohibit you from coming in.
Correct.
I think that's a wonderful thing that needs to be
Yeah.
studied, and I would welcome that. I think all the judges would welcome that.
Yeah.
And I think that's.
I was mad at people like you before when I was on the bench. I mean, I was like, no, you got to
And-
tell me this information.
And the down the line challenge is when clients know that you went to court and testified against them, then your
Correct.
clients aren't coming back to you, and so your therapeutic relationship is disrupted.
And
What I would
Potentially
suggest.
the future of that
Yes.
child's experience with therapy and ability to access
All
that.
of the
Yes.
things, all the things. So I would tell judges like Judge Holdridge, I know you really want it, but you have to honor that they can't give it to you,
Yes.
right? But
Right.
that's the rub. What I would say is that the National Center for State Courts is probably a good resource for us to go to. I don't have an answer to your question now, but the National Center for State Courts can, and we can ask the National Center which states, we can identify that problem, which you have so beautifully articulated, which states are doing that well and have a system that protects both the mental health, not protects, but allows you to do your job. I don't mean protects you in a defensive way.
Protects clients
But
and-
protects
yes.
clients and does that. And that's why when we did the collaborative law training, mental health professionals came up to me and said, if the law would do divorce like this, we would come back and participate. We would be eager partners with you because this actually aligns with our practice ethics and with our practice protocols and what we think is good for clients. But since the law is in this adversarial role, practitioners say, I just can't really, I can't, my ethical rules don't allow it. So collaborative divorce is a huge answer to that question. It's not an easy problem to solve, but it's a different system. It's sort of a process that would be more favorable to that struggle.
Be an easier way to work. And as Judge Holdridge laid out, is everybody in the courtroom has a different role to play, right? And the judge's role is everyone's kind of is an easy one to see. That he or she's the one sitting up there in the black robe and's got to make the decision ultimately. But each individual that comes in is extremely important. And maybe the idea of a confidential position paper that goes to an in-camera inspection. But then we also have the issues of maybe the other side or either side doesn't have an opportunity to confront, right? Or, you know, our system is set up to give everybody a fair access, but that's not a very good way from the issue that you're describing. So certainly maybe the National Center, I think, is a great idea.
And it's not a good process for the well-being of the child.
Right.
I mean, if we could get some confidential information, then the judge would be in a much better position to make a better decision.
Yeah, I think for us, our ethics say that the person doing the evaluation should have a chance to evaluate both adults in that situation and the child from like a neutral perspective, where I may have had a previous treatment relationship with like one parent and the child. And so you're often sort of not on equal footing coming into the process
That's right.
altogether.
Well said.
Thank you, Dr. Birch. Ms. Shelton.
I think you might have kind of answered this, but I'm going to ask just to be clear. So I think a lot of that's come before this task force, and Judge Holdridge, you did kind of address this, is when the findings aren't validated, which is now substantiated, or an arrest isn't made. That's when it gets really complicated. A lot of what we are being told is that when that occurs, that's kind of used as evidence of this didn't happen in some of these courts. And is this a training issue that needs to be addressed of like, this doesn't lead to that answer?
Well, it
or-
could be, especially in criminal. In criminal, it's different because you have to realize that, as I explained before, I mean, in criminal, they can say, the DA can say, I'm not prosecuting only because they feel they do not have sufficient evidence to prove their case beyond a reasonable doubt. And I would always tell when I was in court that just because the DA is not prosecuting doesn't mean the abuse didn't take place. It means that they don't have enough evidence to be able to prove their case beyond a reasonable doubt. Now, the DCFS, that's a different matter. I mean, you know, if they evaluate it and people want to use it both ways, and it's difficult for the judge to see exactly how to use that. If DCFS went through and did a study and they what do you call it? Unsubstantiated now.
Isn't it? It can be inconclusive, unsubstantiated, or substantiated.
And then does that make any bad reference on the parent that reported it, you know, and that is going forward with it, and it shouldn't, but I mean, I know that maybe some judges would think yes, that, you know, this person made an unsubstantiated report and there was no basis for it, and that should be maybe held against the other party. But I don't think we have any rule, and maybe that would be something that we could put in a rule or in the code of evidence or something. I mean, that could be added somewhere.
But I don't, in my experience, to sort of lay the groundwork here, the fact that DCFS unsubstantiated something would not be able to get lifted from here and dropped in my court. Like DCFS
That's where I'm confused with
said,
how that's
right.
happening.
DCFS said it's unsubstantiated, therefore. That's not how that would work.
No.
The mom would get on the witness stand and say, I said this happened, these are my facts. I reported it to DCFS and they unsubstantiated, and that would just be a factor that I'm considering. But it's not like that, it's not like the DCFS process comes into my court and we do what's known in law as taking judicial notice of something, right? Like, it has to, again, be proved.
And it's not always the mom who reports, right?
No, or
They
dad.
can't even
No,
tell
I
you
just
who-
used an
it could be a
example, right? It could be a
right?
teacher,
And
it
they
could
shouldn't by
be-
law tell you who it was.
It could be, it could be anyone
yeah.
who makes that report.
Right.
It could be a mental health professional who makes the report. What I'm simply saying to you is there are rules of evidence that govern the court, and we wouldn't just take it on somebody's investigation that outside there something happened that we should, because we would want to know how, why, how'd you arrive at it, what information did you have,
And certainly,
what information
just-
did you lack?
I would say another way is that's just a piece of evidence to follow with
piece of
that is,
evidence.
because something additionally might be introduced into evidence at the court that DCFS did not have an opportunity to see yet. And then so the fact that they've made a determination at the DCFS level still doesn't preclude the district court from making a different determination if more evidence was introduced there. Or even if it's the same evidence, the district court judge has the opportunity to weigh it differently and look at things differently and judge the credibility of the witnesses on the stand. So I think from your initial question, yes, it needs to be introduced into the record, and just because their determination was made doesn't necessarily mean
But
that's where it has to go.
as we said at the beginning, the concern that I have, and it still is that in family court, there are no rules. That's where, what weight to give to this, should it be introduced or should it not be introduced? Should a mental health professional have to come in, even though her ethical standards don't allow it? All of those rules should be, and we probably need in the Code of Evidence a section on family court, because the only thing we have that I know of in the Code of Evidence is that the rules of evidence in family court are relaxed. I mean, so that means you can introduce whatever you want, whatever the judge wants, which makes it more difficult, because that means if that goes, there's no rules. Every family court judge is using different criteria for what is going to be introduced into evidence. And that is probably a problem.
The rule is intended to allow for a little more leeway, right? But you still, as a judge, have to make sure that you're relying on something that is credible, that is substantiated in some way, that is, right? So it's still a balancing of the information, because you want to, the whole system is designed to get us to the truth. Like, the whole system is designed to do that, right? The question is, how do you use the system to get you there?
Thank you.
I hope that's helpful. Did we answer your question? Yeah.
Okay, thank you, Ms. Shelton. Dr. Thurber.
Just wanted to mention a couple of things that might be relevant to our discussion. One is, speaking as an individual who used to be hired to do these evaluations in child custody and sexual abuse, I made a mistake initially when I was hired by an attorney who asked me how much I charged. And I said, well, whatever
Dr.
you
Thurber,
charge.
would you speak a little bit more into the mic?
I said, whatever you charge as an attorney. And wow, you can really become rich doing this. But I quickly found that I had a confirmatory bias. There's been a lot of research on this. So I became attuned to information that would be helpful to the attorney who hired me. And you can't get away from that. So finally, in one of my few noble gestures, I decided I'd only do these things for free. But the point is, the importance of having neutral evaluators, I can't emphasize that enough.
That's why the appointment by the court matters.
Exactly. I just wanted to emphasize the point. The other point I wanted to make, at LSU, we're writing a book for the American Psychiatric Association, and part of that book has to do with the epigenome. And not many mental health professionals are aware of this, but early trauma to children, including conflicts in family, you mentioned 2-year-olds, can actually affect particular genes, turning them off, that help the child to deal with stress throughout the lifespan. Okay?
It's fascinating research.
It really is.
And really important.
And anyway, that's fairly new. You're aware of it,
Yes, I am.
but many are not. So I just wanted to point that out.
Yeah. No, it's such important research for us to understand, because so many people will say, like, I don't remember what happened in my life. My first memory, I think, is when I was a 5. But what happened between 0 and 5 was critically important to my health, right? So the fact that a child can't remember it or doesn't know it, or that we didn't remember it back as children, this is one of the things that I say about courts all the time. We have no problem getting experts in the Toyota case that I recommended to you, or in a blowout case, or in a medical malpractice case about cardiology. But when it comes to family law, we say, I'm a daughter, I'm a mom, I'm this, I'm that, I have experience in family law, I can do this, when in fact it's the hardest area, right? So there's sort of this, I can do this work because I am part of a family in some way, a dysfunctional one, a functional one, whatever, whatever that your own experience might be. And so the assistance of mental health experts in this space is really helpful. And your point about being court-appointed is so important, which is why we're struggling with this funding issue, right? Because when the parties pay, as Judge Holdred said, it's easy to then cross-examine that report. Well, so-and-so, Mr. Holdred hired you, right? Which is why you wrote an opinion favorable to him. So a court-appointed expert in these cases is really important, and finding a fund to do that so that the expert is not beholden to any side and can give the court the information they need is just really how we get there. I'm not sure, but that's a really important thing. So thank you for your question, and thank you for your work.
Thank you so much, Dr. Thurburn. That was a very good response. And before he even kind of mentioned that about especially early brain development and trauma, I was thinking about Dr. Charlie Zena, and I was wondering how many of the judges have actually ever been through his training, right? Because it is life-changing and life-altering. I know it was for me, for someone who I consider myself to be a strong advocate for children, and I thought I really understood a lot, but I learned so much more that I did not know, and I really recommend everybody taking that.
So I
particular
remember
program.
Senator Marzell, you telling me when we first met, going, why didn't I know this? Right? So why didn't I know this? And so he is a really important partner, he and his team, and also there are other experts that really help us understand that work. And so, it's all a matter of, I hope that his work is still, he does a lot of work with the department still, and to help, casework, to help all of us understand about the impact of early childhood experiences on not only the developing brain, but if you don't know this about the ACE study, the most important work that came out of that study it's not just how it impacts the behavior of a child as the child grows, but it affects our mental and physical health as adults, the child's mental and physical health outcomes. And so understanding the social determinants of health from the genetic, the turning off and the turning on of genes, and the way the brain rewires itself having experienced trauma, that ends up with early morbidity, early cancer, all the health consequences that come, right, are super important. So Dr. Zena is a hero, he is a mentor, he's continuing to do really good work, and we're trying to figure out funding mechanisms to continue his work going forward.
Okay, well, we certainly need to do that. Ms. Wascom, another bite at the apple here. No problem.
Y'all talk, the more questions I have. And y'all might have said this when I was trying to scribble notes. When a case comes before y'all, are you always notified of the results of the DCFS investigation?
No.
Okay.
A case can get filed in family court, and we don't even know that there's a DCFS investigation going on.
Okay. That was it for that. And then this is sort of like a broad question.
Let me just
Yeah.
interrupt you. And DCFS might not even know that a family court case has been filed.
Right.
Right? Like
Yeah.
this isn't a blame issue, it's just a,
No, I don't.
right?
I'm
Right?
not placing
We may
blame
not
anywhere.
know, and they may not know that a family court case was filed arising or connected to their investigation.
As you were talking about substantiated or unsubstantiated, I was like, I wonder
Yeah.
in there. And then I have another question going back to the no training, specialized training, and what some possible consequences, just for the children, could be. And let's say within the system, you see a judge that you believe, maybe it was not intentional, but you felt like because they had no training that they should have recused themselves. Is there any recourse for fellow judges? How does that work?
What you mean as far as, I'm not.
So let's say, I'm just thinking about the 30% that had no training, and I think everybody in this room knows that, like, if you don't have, like, things are very different than what, like, a layperson would know about child abuse, okay? And let's say it might be a newer judge, or maybe it's not, and a case comes before them, and it could be just a clear lack of training, right? It's not intentional that they caused harm, but it was clearly the wrong judicial decision. What do the other judges, do y'all have any options?
So I would say there are two options.
Okay.
And maybe there are more. But the first thing is if a judge makes a decision that is not supported by the evidence.
Okay.
A party will appeal that, and it would go to one of our
Just the
appellate.
Court of Appeals, okay.
Court benches, you have an appellate, right? If a judge is consistently making decisions that are not supported by the record of their proceeding, or through their actions, it is reported that they are just not following the law or just not doing the job, then the Judiciary Commission could step in, right? So there are two sort of avenues. One is the appellate avenue to correct the jurisprudential error. The other would be if a judge, if the Court of Appeals says, if Judge Holdridge says, Judge Landry, you can't do that, and then I do it again. And he says, Judge Landry, you can't do that, and I do it again, and they reverse me like the fifth time, right? At some point, it would
Okay.
become a disciplinary matter.
Yeah, I think it was just like a sort of
Yep.
thinking about the possibilities if like you, and it's, I'm not saying it's intentional, I'm saying that,
And then there are informal processes through our mentoring process and there are other processes.
I think I need to say, because I know this has come up before, if a judge makes a wrong ruling, that is not grounds to recuse the
Correct.
judge.
okay.
The remedy for that is to go to the Court of Appeal. So if you don't go to the if you think the judge made a wrong ruling and you don't go to the Court of Appeal, and then you file a motion to recuse saying, Judge, you made a wrong ruling and I want to recuse you, the judge that's hearing that should say, no, this judge is not going to get recused. Because
Yeah,
that
I don't
recusal is not a method of an appeal. A recusal has to have some other
Good point.
basis other than that. So, and I hear a lot of recusal cases, just because a judge ruled what you think is incorrectly.
Oh, no, and I really am more of a pattern of behavior if,
Yes.
like, who steps in and is like, look, we know that this isn't with malice intent, but we believe that you need more training. And like where, like, I guess that's where,
There are informal and formal processes for that.
And you can call, which happens quite often, you can contact the judicial administrator. If you think that there's a pattern that you don't think this judge has enough training in this area or is, not able to properly handle those cases, you can surely contact the judicial administrator.
okay.
Just, yeah,
Yeah.
Thank you.
yeah.
Okay, thank you so very much. Senator Mizell.
And before we begin, I just want to thank the Supreme Court. They told us we were going to come here for 10
like
minutes.
10 minutes.
10 minutes to get y'all information.
Just go,
It feels
just
like
go
I feel like
No, it's fine. I mean, we're fine.
But we're
He's-
okay. We're
we're
okay.
fine.
But I just want to put it for the record that we were told, come for 10 minutes.
Can y'all just go help out a little bit?
Show up and answer a few questions and then go.
I'm really, actually, I want to just
They do that to
echo to
us every
say,
year.
I am grateful for your interest.
Me too.
It's just really important, and for the time that you're giving, it's just,
It's always fun to have the
it's
judge in
just,
the hot seat.
because they're looking at us. so
We
just wanna
do
tell them.
apologize.
We just want to tell them.
That we
Anyway.
certainly have gone beyond the
I don't
10-minute
even have a
limit.
question. I just wanted to make like an observation because this, and I know my pro tem there, you hear in every segment of our state, I don't want to say injustices, but bad practices that result in our children's quality of life not being what it should be. I mean, I've been at an early childhood conference in New Orleans. That's why I was late. We were in a DCFS conference the other day and fatalities came up. My fear, and you all are giving us best practices. You're here because, frankly, you're the A team. I'm worried about the C, D, F team.
Sure.
So that's what is my concern. You all, you can have all the best intentions, and when you said, I dream they do, we all dream they do, so that's that. But I would hope we don't look at this situation in isolation. You look at Casey Family Foundation, we're 49th in the country, and it's not just because of this, it's because of a lot of things. And if we don't look at the whole process that we put our children through, from birth to pushing them to the TOPS program, whatever, we're missing an opportunity right here.
100%.
And I think that, it's, we don't know what DCFS, y'all are trying to figure out your role in there. This should be like a absolute well-oiled machine, because, that's all I want to say.
And
I just hope
Senator,
there's
if I can say, and I think all of us want to strive to get to that point, and that's why this task force and this committee, and I thank all of y'all for your participation in this, is to try to get us to that point. But also to know that we might only be talking about 2 or 3 out of 100 cases each. And each 2 or 3 are extremely important, because every single child is every single district judge and family court, juvenile judge that are there, that case is of the utmost importance. But we don't hear the 98 of the 100 that they have gotten right, or at least right's not is a relative term, but at least have been able to move through the process appropriately. And so I do believe we need to focus on every little misstep so we can make that 100 out of 100. But I don't want to make it seem like our judges down there on the front lines are messing this up all across the state. But I want to be here to make sure that every single case gets there. And I think the training, the funding, and some oversight, some legislation, some more suggestions from our Supreme Court and their plenary power, I think all of that is a framework to help each and every child of the state of Louisiana.
Right, but that's the same thing with a law enforcement officer, or a teacher, or a doctor, or a
Absolutely.
nurse. Our role, and thank you, because this is what you've done. You brought accountability where there was no accountability, and I think that's
important.
something where, everybody's busy, just like the Supreme Court sent you guys. Everybody's busy, but we've got to take time to have oversight and accountability, or we're going to keep dropping the ball on quality of life for our children.
100% agree.
Okay.
And I think we've brought up some changes that could be made. I mean, there are changes in family court that need to be made. I mean, I think we all could agree upon that. Having more mental health counselors, having attorneys for children, having more training for judges. I mean, all of that are things that we could accomplish. Having better, maybe getting confidential information from DCFS to a family court judge, which just comes confidential to the judge. I mean, there's all kinds of
Right,
things that can be,
right.
but that probably is going to require, in most situations, legislation. I think we probably.
But if you look at the states that are 1 through 10 on the Casey Family Foundation, they're doing something that we're obviously not doing. So we're not creating a whole new world. We're just looking at where it's worked. But again, I think the accountability, we've got
Right.
to hold, yeah.
And one of the things that I've been spending my time on, and Dr. Thurber, I'll share this, perhaps you might be more interested, or I hope all of you are interested, is how do we get upriver? And so we're beginning to create a medical legal partnership where we're going to embed lawyers in hospitals, right? So that we can get ahead of the issue early. What is impacting that child, right? So because the early health outcomes really matter. So just as a doctor might refer a child to pulmonology for consistent asthma, right? They might also refer them to a lawyer to address the mold in the house landlord-tenant issue, right? How do we quit the cycle of a child continuing to come in and out of healthcare when their healthcare issues might relate to a legal issue? So there are all sorts of innovative ways that we need to be thinking about, and particularly our work with DCFS, to think about how to get ahead of to get upriver, if you will, right? To figure out why so many of our children are impacted by, but we know a lot of the answers. I mean, we know a lot of the causes, right? It's just a matter of accountability, correct?
And I think we go on autopilot. Because we're big on, we've always done it that way, we've never done it this way. Well, we're 49th.
Yeah, 100%.
Yeah, that's.
I agree with you, Senator, and it's really important for us to figure those things out.
Senator Mizell, I think you hit the nail on the head, and I greatly appreciated you. I mean, I think those comments could not have been more accurate because this is, I believe, is the 18, right? Before us, these are individuals who have gone beyond, over and beyond. That's what has led them to where they are today, I do believe. But I am concerned about CDNF too, right? I'm concerned about those who. Maybe I shouldn't say that, but I am concerned about those who have not taken the additional classes as Judge Guillory has because they wanted to. They are offered, but they're not going. And they may not have a docket full every day. Those things that I'm concerned about. I'm concerned about those individuals who have not looked extremely at every case. And so we know that happens. It happens in every arena of life. You got the people that they do 99%, right? Well, you see that 1% who does not. But I do have a question kind of following up on Ms. Wascom. I think it was Ms. Wascom that asked a question about does DCFS knows, or when there's a case that's pending or open, do DCFS know, or do you guys know what DCFS knows? And so I'm going to ask staff to do this for me because this is something I really want to see if we can do. It seems very simple to me. And it seems like there should be some kind of technology piece that is not intrusive, right? That can show if there is a pending case. It doesn't have to go into details of what the case is, but it's enough information where that can lead into, that can allow the judge to know that there is something happening here.
But Senator Marrow.
Oh, hold up. So add everybody.
I feel like there's just
Hold on. Hadley. All right.
I feel like there's communication barriers on all facets. Like if we would want that for the court, which would be helpful for DCFS to know family court's happening and vice versa. I feel like that same would go for DCFS knowing if law enforcement's involved and vice versa. I feel like there's this constant communication barrier amongst all our multidisciplinary team to know who's involved, what has been done. And so if it does eventually go to court for criminal or family matters, all information would be laid out a lot easier. Well, that's the utopia
Well,
and the hope.
The only thing that you have to remember, though, in a judicial proceeding, the judge can only get the information that is introduced by the parties. I mean, the judge in a judicial proceeding cannot go outside and look for the information. We can't go try to find out information on our own because, then the lawyers are going to be screaming and hollering, where did you get that information? Because it was never introduced into the evidence.
Right.
And as Judge Balfour said, all of it, when it goes to the Court of Appeals, we have to have a record that the Court of Appeals can review. So if the judge got information, through a notice or something from something else, but that wasn't put in the record, that wouldn't be part of the record, and maybe the judge is relying upon that to rule in a certain way, but, nobody else knows that that's why the judge is ruling in a certain way. All of this it's a complicated issue, but we can do better. I'm like Senator Mizell, we can do better than we're doing now. There's no doubt we could do better and have, in place more rules, and we maybe need to show. I like the idea. If there's 10 states that are as the gold ribbon, why don't we go look and see how they're handling stuff? I mean, that would be simple enough. It looks like for us to do in the state,
And not an attempt to open another can of worms, but again, as Judge Holdridge was indicating, what a district judge has there is what has been filed and presented to it. They can't go outside of that pleading and doing their own work. It would be maybe that piece from the clerk's office that's filed, and the clerk can do, because everything's filed with the clerk's office. The clerk then assigns the file to the court. I would get it there if if the clerk just ran it through a database and said, this name or this last four digits of the Social Security number has something open, maybe they could have that stamped there. I don't know if they have that capability. And again, just like we were talking with the judges and the district courts having different funding sources and different access to funds. Our clerks are also all local in all their parishes and have their own technology. And so it might have a different component too, but maybe they can be brought in as an assist.
So with that stated and said, we're going to look for you guys to assist us with that.
Well, I might be going really out on a limb here, and my
Come
judicial
on.
administrator might be going, "What are you talking about?" But it might be, and I know that I've got some lawyers in the room, that when you file your custody case or any case in family court, there could be a cover sheet that asks whether or not there's any DCFS, whether the family's ever been DCFS involved. Now, I don't know where that would get the judge, right? But we could at least know that. And then we could, I just think that there could be a way. For instance, we do this in the domestic violence. So when you all pass the domestic violence legislation, I know that Kim Sport's in the room, right? There's a cover sheet that says, so when they would come to my court with a request for a temporary restraining order arising out of alleged domestic violence, there was not at the beginning, but then we asked for this to be changed to say, am I in any other court anywhere? Because the litigants might have gone to one division that with a custody case, and they didn't like the answer there, so they filed a domestic violence case with me, right? And us knowing that was really important. So we might be able to do this on a domestic intake sheet, where you could at least know whether there's a DCFS, whether the family's ever been DCFS involved, right? I just haven't thought yet about what we would do with that information if we get it, right? Because we would call DCFS and they would say, we can't give you those records, and maybe they should, so it's worth us thinking about, and I'd be happy to brainstorm with the right group of thought leaders, all of you all are in that world, to think about how we might do that a little better so that we can exchange information more readily and more reasonably while maintaining the integrity of the processes and our own respective roles.
Okay. Representative Edmiston.
Thank you, Madam Chair. I just want to say, am I on?
Yes,
Okay.
we can hear you.
I just want to say thank you so much for the three of you. This is and I know it was late, but I've heard enough. And of course, I know Judge Holdridge. I know he's excellent. But I am just so thankful for all of your input. And the bottom line here is, well, first of all, Senator Fields and I have a resolution looking at East Baton Rouge Family Court. In doing what I needed to do for this resolution, and by the way, the Supreme Court owes me a report, and I know that Senator Barrow and I are bearing down and asking for that report, and I know we'll get it. But in all of the people that I've met and the cases I've heard of, y'all, I just feel like the kids are the ones that are getting the shaft. I feel like so much of the time it's about the mother and the father and the things that we need to know about the children we're not knowing. So I love the idea of the cover letter. Look, I know there's more that we can do to break those communication barriers. And that is what the major thing I've seen is people don't know what they need to know in order to make the right decision. It's not one person or one entity's fault. It's just the system. I hate systems. I'm in the wrong place, I know, but I hate systems. But
I'm not going to make no comments on that.
Yeah, I appreciate what y'all have shared with us, and we really need your help because we intend, this group of legislators and this whole task force intend to do something about this because it's just gotten, to me, way out of hand. And so I want to thank you all for being here and for sharing. And I know you're stepping out on a limb, but we appreciate that. Our children deserve that. And so that's all I want to say, Madam Chair.
Well said. Our children do deserve that because we are shaping the lives of individuals who will one day become adults. And based upon their experiences, because no child, and I always say this because I so wholeheartedly believe in this, no child picks their family, they don't pick their environment, they don't pick their situation, they don't pick their income, they don't pick any of those factors, right? And when things happen to them, they depend on adults to help make sure that they make it right. And this is the highest branch, or not highest, but you guys are the branch that make the decision, right? Y'all make really tough decisions on what happens in their lives. And we need to be making sure that we are doing everything that we possibly can to get it right. One wrong, which we're going to have a one wrong, right? We're going to have more than one wrong. But one wrong is one too many.
Agreed.
Great.
Okay. Ms. Wascom, number 3.
I'm sorry. Y'all have to know I'm like super inquisitive about a lot of this stuff.
Oh, good.
And I really just want to make sure that I understand very clearly. So, and this is not, I'm not like coming down on anybody. I'm just trying to like process how a loophole could be closed possibly. So am I understanding correctly that if a judge rules on a possible custody case, and let's say neither party knows of DCFS investigations, however, there have been reports made, maybe by like teachers or neighbors or whatever, that rulings are being made in the delay of DCFS doing an investigation that will affect the well-being of a child and their safety?
Would you allow me to rephrase your question to make sure that I understand it?
Yes, I know that it sounds like
No,
convoluted.
let me see if this is what I heard.
Okay.
Is it possible that there is a DCFS investigation that's ongoing?
Mm-hmm.
That a family, one party or the other, files a custody case?
Or it doesn't
Or
have to be.
teacher.
It could be somebody, maybe.
No, it has to be, and this is what I want to be clear about.
Okay.
In a custody case, it's got to be a mom or a dad that files. I mean, maybe a grandmama, but like a teacher can't file for custody.
No.
Right, okay.
I'm saying they file a report with DCFS.
Oh, all right, I understand. So there's a DCFS case by whoever has reported it.
Yes.
And it could even be mom and dad and they don't tell us. But like it could be somebody that mom and dad doesn't even know about, and then we get a custody case. Could the custody case be proceeding and a judge be making a decision about custody while DCFS is investigating and the two systems not know? Is that your question?
Yes.
100%.
Yeah, absolutely.
Definitely.
Yes.
Do you,
Often.
can you
Yes.
envision a nightmare of a scenario where a judge makes a ruling without the knowledge of an investigation that maybe that child should not be placed in custody of that?
Yeah, I would hope not, but sure.
Oh, right,
Yes,
right.
but yes.
I'm just saying, like,
Yes.
You know,
Okay.
and it comes out more, that scenario can happen more if one of the parents is a self-represented litigant.
Right.
Not knowing that I should go and introduce something, or I should bring this up because possibly the other party who doesn't want this DCFS to come in or anything is proceeding, and this self-represented litigant is not bringing it. But the judge cannot, on their own, go out and start searching.
I understand that.
Yes.
I'm just thinking about the relaxed
But it
code
would
of
be,
evidence.
but I would say this, it would be unlikely.
Right.
I'm going to say this. Can I envision one? Yes. It would be unlikely because somebody in the custody, Dr. Hook can answer this, but if there's an investigation going on and the DCFS has not told either parent that one's going on, that's a problem, right? So one of the parents is going to know, and one of them wants us to know. But the other doesn't want us, like, one of them wants us to know. So I would find it.
But also, I guess, like, I'm just thinking about, like, the delays, right? Like, maybe no one has made, we've had discussions on, like, who is a mandatory reporter. There's been lots of discussions on people
let's-
saying that, well, I didn't know I was supposed to report, right?
Let's say there's a scenario where the judge makes a custody ruling in your hypothetical, and there was an ongoing pending investigation by DCFS. And ultimately, the investigation by DCFS uncovered certain evidence that was not available for the district judge when they
Yes.
made their initial ruling. They could simply file a motion for change of custody, add this new information, have another hearing. I know that's moving children, and that's
as long as
its
there's
own
a-
issue, but there's certainly a mechanism to fix if
it.
there was a bad decision
what-
in your
what is-
hypothetical to.
Let's say that that motion is filed. What is the timeline to get in front of a judge?
That varies depending upon
you could
the
do-
area, but those are generally relatively
You-
quick.
Yeah, you can do an ex parte custody order. I mean, if you follow the guidelines in the code, if you make sure that you follow all the guidelines, you give notice to the other party and all that, the judge can sign an ex parte custody order
Within-
almost immediately.
I'm just trying to brainstorm of what would be the easiest way for all agencies to close a loophole. That's all. I just want to make sure that I am not misunderstanding.
You asked me, could I envision? I could envision, but I believe that there are enough protections in the system, in the way that we're communicating, that would be unlikely that a court would proceed and not know that there was a DCFS investigation going on, because the market forces at play would cause for us to know about it. So the court could just say, I know that that's happening, I'm going to wait for the investigation, because the court would want the support of the department to figure out what was going on. So there are lots of scenarios there. I think that's a very open-ended, question, and I appreciate you asking it. But I think it seems to me that the court would know that there is a pending investigation. Now, it could happen like overnight, right? Like a case is, right? But a court would welcome, I think,
More information about it.
the more information, the better.
Okay.
Now, you could have two courts. I can envision this in East Baton Rouge Parish. You could have DCFS in juvenile court, and you could have the civil court, and the civil court and juvenile court may not know both what's going on. I think that could happen. I mean,
Well, and then if you get into criminal charges.
yeah, you
I
could
mean,
have three courts.
three,
You really,
yeah.
you could almost have criminal court in Baton Rouge. You could have
Civil
criminal
protective
court,
order.
family court, and juvenile court, all having something to do, and they
guess-
may not know about the actions in the other courts.
And I guess that would be a question, like, to ask y'all staff, like, do you think there's an easy way to click, like a one-page, like, report that's sent? I mean, I don't know how you would do it. I'm just, maybe someone
It
has
seems
ideas.
like it should be. I mean, as I listen to that, but I'm not sure, but it seems like it should be.
Yes, we
It's
could.
something
But
should definitely, it needs to be studied.
But judges could also, in our training of judges, right, it'd be very wise for me as a family court judge to say, have you ever been involved with the Department of Children? Has your family ever been involved with the Department of Children and Family Services? Have you ever had a criminal? Like, you can't just ask a broad question because they need, if they're not represented by counsel, they need specific. But a judge can definitely ask those questions. There's nothing that precludes a judge from asking the questions about the scope of involvement of other agencies that this family has been involved with. There's nothing that precludes a judge from doing that, and a judge should do that.
A bench card, almost.
Yeah.
Checklist.
Say that again.
Well, through the Judicial College, they produce a number of different, what we call a bench book or a bench card that is there. We'll do some for unnatural citizens, illegal aliens. We have one for language assistance to make sure we know what language somebody might speak, because we'll have people from all different, we need to bring interpreters, but maybe a potential bench book there is a checklist that each judge says to make sure that we follow these things. There are a number of different opportunities and options that could be available.
It just seems like there should be a way that could be done. The communication piece is huge, and I know that y'all have heard us say that over and over again because it's one of the things that have been consistent in our hearing. Dr. Hook, and maybe she can kind of tie up some of the loose ends right here.
Certainly try, Senator Barrow. I did want to just thank everybody again because this has been, I think, really powerful discussion that we're having today. But I wanted to go back to the unsubstantiated findings for DCFS and especially like how they are weighed in a family court proceeding. When we first started this task force, it was really focused on sexual abuse for children. Obviously it has expanded to all of child abuse investigations, but sexual abuse is the most difficult for us to substantiate date because there is often no physical evidence. And quite often the child does not disclose or there is delayed disclosure. And so, I think somehow we have to, work together to make sure that everyone is educated on when it's a sexual abuse allegation. It is extremely difficult. We have to have a burden of evidence as well, or proof in order to substantiate. And if we don't have medical documentation to show any physical indicators, and if we don't have a disclosure, and we just have maybe one parent reporting one thing and another parent reporting another, and often, like you're saying in court, we're getting kind of the similar information and interviews with collaterals, where we have one whole family saying this didn't happen and another family that says that it does. So, I would say just weigh all of the evidence equally and independently, and don't rely on the finding of a DCFS investigation, especially in sexual abuse when it is unsubstantiated, because we do have to have, like I said, a burden of proof or evidence.
There's a saying in court where you say, we're going to let it go to the weight. Like, we're going to let the information in and give it the weight which we think it deserves, and a universal understanding of what unsubstantiated means. It doesn't mean it didn't happen.
Correct.
That's the lesson. It doesn't mean it didn't happen. It means we can't, in this moment, with what we have, prove it beyond a reasonable doubt. And remember, we all have the important, really hard decision to make about whether or not you're going to put the child through a process of testimony, of courtroom, of all the things when we can't get to a result, right? There's a lots of balancing, which is why you've got to have good people in these jobs who are dedicated to doing them well. And
many times interviewing children, but children in the same family give totally different things. One says yes and one says positively no. And I just want to make one other thing. This is a little technical, but just so everybody understands. If that happens and you're in court and all of these people testify and the judge weighs everything and makes a determination, and then you come to the Court of Appeal, the Court of Appeal is more than likely going to uphold what the trial court does, because it's manifest error. That's the trial court's function, is to see and make those determinations. And if they make those calls, unless it's manifestly error, no person could make that call, the Court of Appeal is going to uphold what the trial court says. So I just want to make sure you do that, because plenty of people, I'm not happy, I'm going to go to the Court of Appeal. Well, if it's just factual determinations that the court makes, when you go to the Court of Appeal, the Court of Appeal can't change that, because the Court of Appeal only has this cold record, and the trial judge was in there weighing and listening to every person and saying whether I believe those people or don't believe those people. So it is, a little more difficult, to come to the Court of Appeal if that's all you have, is just the court weighing it in a certain manner. And many times you're going to read, in my opinions, if I was a trial court, I would have made a different decision. However, I'm bound by the rules to follow what the trial court did.
Yes, and unless we get a new report, so for example, we may have had a report that was called in for an allegation of, abuse, and we investigate, and at the time we don't have anything that supports that allegation, we would not re-investigate that case unless new information was present. And sometimes we don't find out about that new information, or there isn't a new report that's made. So it could be that the child follows up with a behavioral health specialist and makes a disclosure that we never know about as an agency.
And that's certainly a good thing about the family court system that we have, is any new information would be a change of circumstance. You make a different determination, and that individual can then file something new with our court. As Judge Holdridge indicated, you can maybe even, if it rises to the level of an ex parte change of custody, which means judges makes that determination almost immediately, and then we'll come back and have a hearing in a couple of weeks to talk about it. We'll just remove that child out of that situation right now because of the allegations that were presented are sufficient enough to warrant that, or they'll have a hearing as quickly as possible. And I think, Ms. Wascom, you were asking earlier about the timelines, and a lot of these courts try to do these things, well, all of them do it in an expedited manner, but we're talking within a week, 10 days, 2 weeks max. Every court has an ex parte rule day that bring in these change of circumstances to get back before the court as quickly as possible.
And Judge Balfour is talking about the 19th. If you were in Ascension, Assumption, St. James, you may not be going back to that court for a whole month. I mean, you may not be going back to that parish. So
Well, that's
there
why
is
the
a
ex
ti-
parte is
there is going to
important.
be a time delay before you have to get ready to go back to that court. I mean, that's just how the court system is set up.
Okay, Representative Edmiston.
Just real quickly, I've been trying to find this information out for about a year, and I keep getting different information. As far as family courts, do you know how many we have in this state and where they are? One in East Baton Rouge Parish, is that correct?
Yes, ma'am.
He's
Yes.
raising his hand as
Yes.
well, yeah.
Yes.
That's the only one that is a family court. I know
Well,
there's
yes,
some
but
that.
the reason that you're getting different answers is because it varies. So in Orleans Parish, for instance,
Right.
there are 3 dedicated divisions to family court.
Okay,
2 of the judges are permanent, 1 rotates through, or maybe they've changed the rule a little bit, but they're dedicated to the family docket.
Okay.
In other jurisdictions, for instance, the 9th JDC, the judges might every 6 years rotate their dockets. But
Okay.
in some jurisdictions, the judge handles family one day, criminal one day,
Right.
right the other day. But the East Baton Rouge Family Court is
Is-
the only,
that's
I'm
what
not
I'm
sure.
writing down.
St. Tammany, I think
no,
possibly.
they have 2.
They have two family
div-
court judges, but I'm not sure
They're-
how it's set up.
And Representative
I'm not-
Evanson, in the 23rd JDC, they were just allowed last year a new judgeship, and
Yeah.
that judgeship was designated as a family court seat. And I think the difference
us,
is
right?
you're.
That's us.
Yeah, but
Yes, ma'am.
that was,
that's
it was
not-
not
that's not a family
designated
court.
as,
Well-
it's the judges have designated.
Right, and that-
family.
and that's where I was
That's
going
what I'm
to
asking.
your-
So it's not like, it just not,
Yeah.
it's not like East Baton Rouge is just.
Your
family.
question was, it just kind of gets into a lot of more technical type answers. There's one dedicated court constitutionally that's set up that has its own budget, its own,
Right.
they are completely different. They have a different setup than the 19th. They are those 4 judges and do their own. The other courts, they're folded into the court, and they might
That's
have
what I'm
dedicated
asking.
sections
Yeah.
of those judges that is what they predominantly do. And they may rotate out, they may stay in there and
Right.
enjoy it and want to do their whole career there. But there's only one truly
Which is why
established one
we did our
for.
resolution for that too. And in y'all's opinion, I mean, Guy, you said it was a little loose, that there aren't as many hard and fast policies or rules in the family court. Is that, I mean, we need to do something about that, in my estimation. Do y'all agree with that?
I have been saying that. I have been saying that we probably need more rules in the family court.
Okay, well, you never told me that.
We need rules for appeals in the family court.
Yeah.
Because we don't know what's appealable or not. If the judge says, I'm ruling, giving you custody, but I'm going to review it in 6 months, at the First Circuit, we would generally say, that's not a final judgment, so sorry, you can't take an appeal on that.
Right.
There's a lot of things that are peculiar to family court that does not apply to the rest of the courts, and we probably need to tighten it up some.
And a lot
The
of
whole
them
world
are-
has gotten
are
much more
detrimental to-
complicated, so I think this is
Yeah.
getting complicated.
And a lot of them are detrimental to children, is what I've found.
They could
since
be.
I've been, investigating this. So, I just feel like, yeah, we just need to look. We just need to look and do something about it.
Well, I do believe that we are certainly on the right pathway. And so as we get ready to wrap up, I am so sorry that you guys was misled to think that you would only be here.
they do it to us all the time. It's
I
fine.
told him I
happy to-
have a class to teach at 1 o'clock. I
Oh,
said,
my God.
Will I be out at about 10:30 at the longest? You'll be out by 10:30?
We're happy to come back.
So, Senator, I just want to, look, I want to thank you for, I think, and I can't, on behalf of all of us, really to thank you for, it's very easy to sort of knee-jerk a response and to say an injustice was done, we have to fix something. That's like the wrong thing to do. So I'm really grateful for your intentional, thoughtful, multidisciplinary sort of approach to this task force and to understanding how the systems can come together, because everybody's trying to do good work. Right, everybody's trying to do a good job. So thank you, and any additional information that we can provide to you, I know that would be happy to do that, and the court would as well. Not that we're not here speaking for the court, but we have been in this for a long time. We sat for a long time with this jurisdiction, and so, but it is getting more complicated. Right?
Yes.
And so when I used the Toyota example earlier, right, the system was really not designed for families. Families didn't get divorced in the 1950s, like, right? And then when they did, dads worked and moms had custody, right? So as society has changed, we've just sort of morphed family law into the regular big system of an adversarial process, and perhaps we need to continue to
And
do
we
some
made
good
it more
thinking about
complicated.
that.
I can remember when I was a very, very young lawyer that the mother was preference. You give custody to the mother unless there was a reason not to give custody to the mother. Now we came up with joint custody, which made it more difficult to come up with, plans. I mean, it was very simple, divorce, mom gets custody. You didn't have to worry about anything, Father, you work, you pay the child support and spousal support. We call it alimony back then. And this is how you do the divorce.
He's so old.
Everybody can be.
He's so old.
Thank y'all for bringing, just trying to, bring a little humor to this situation, which is very serious.
Yes.
We do want to thank you. One last thing I wanted to kind of like bring up was one of the questions, question number 8, which we heard a lot about, and that's why I wanted to bring it up. It says, when there is an allegation that the child victim has been coached to make an abuse allegation, how often do the expert testimony regarding the coach make a determination? And, that was one of the things that we've heard a lot about that. We've heard a lot of insinuation that is what's happening. But I can tell you with some of the cases, with some of the situations I've heard, I don't believe that has actually happened. And so that was just one of the things I just wanted to bring up. I know that you guys have spent a lot of time here today, but in your wrap up and final comments, if you would like to lead into that would be great.
Goes back to what Dean Landrieu says. These kids love their parents. These kids love their parents, and they will try to tell you as the judge whatever they can say to keep their parents. Most of the kids that come in front of me would want both parents to go back together, which is impossible, but they love their parents. So if a parent says, will you say this, they're going to probably come and say it. I don't know if they intentionally lie, but coaching happens on both sides. It's not something that's just a phenomenon. It happens, and that just makes
Children,
the family much more
interestingly,
difficult.
I don't know if this is your experience, Dr. Birch, but what I found is that children usually get on the side of the underdog. Right? They tend to sort of want to balance the playing field a little bit, right? And so because their desire really is to keep their family together, because the family they know is less scary than the family they don't know. And so but this is why judges need the assistance of mental health experts and need the training. Because when you listen to a child say something, you need to know whether the child had the capacity to say that. I had a child once that I really did think, the only time once I thought this child was coached. And I really dug deeply into that. And then I realized this child is just brilliant, right? This child was just brilliant. And that child is now a 40-year-old and she is just brilliant, right? So, So if you can listen carefully, and that's why these cases take time, because you have to listen carefully to what children are saying and weigh it with everything else. So there's a lot of really good work that we do in that space about how to interview children. And we're trying to do a lot of training with lawyers right now about how to put mental health experts on the stand. Mental health experts, like, I've never been on the stand before. It's not something I'm comfortable with. So they want to be trained on how to do that. They might be really comfortable in their mental health world, but when they get on a witness stand, it changes the dynamic for them, right? So all of that training is really important, and it goes to how children are, to say that the question is whether they're coached, so honey, we're going to court tomorrow. The judge is going to put you on the witness stand and ask you to answer these questions, and I, as a parent, am preparing you for that. As opposed to, tomorrow we're going to court and I need you to say A, B, and C, because if you don't say A, B, and C, the court will take you away from me. And if the court takes you away from me, I will never see you again. If I don't ever see you, right, there's a difference between preparing and coaching, and judges need to be trained in how to hear that, and that's why the mental health work and all of the evidence we get is really important to that.
So again, I do want to thank Senator Mizell.
I'm sorry, but you may have covered it. But if a child isn't going to testify in family court, what is the factor that determines truth or untruth in the story, that in the accusation? what? I
So
mean,
if the
in
child's
in-
not going to be a witness,
Right. I mean, isn't that normally the case? The child is not a witness.
depends. It depends. So sometimes
Okay.
children and very young children do testify in court. It depends. But, okay, so let's assume for your hypo that the child's not going to present.
Right,
And one party says A and one party says B.
right.
Right? We have a series of factors that you all have passed. The legislature has given us a series of 10 factors to weigh the testimony of all of the parties in the case. And we weigh those 10, aren't there still 10?
Still 10.
There are still 10 factors that we weigh to determine what is in the child's best interest.
Okay, so it's an overall 10 factors. It's not just on the.
Like one of the 10 factors is which parent is going to further the child's relationship with the opposing parent, right? Is somebody going to write the other parent out
Right.
of the,
Right.
so there are 10 factors that we have to take the totality of the circumstances of the evidence before a judge and weigh those 10 factors to make a best interest determination.
And that's how Judge Holdridge was indicating, if that ever gets appealed, we'll look at that
Right.
at the Court of Appeal, see the judge's determination on those factors, but we can't go back and have another evidentiary hearing. We've got to rely upon that judge who was there, seeing the evidence, weighing the credibility of the witnesses, making those calls, and that's the importance of our district court judges.
But do you at those points in the appellate court, do you weigh the wisdom of his decision or what he used as a primary factor for making his decision?
Well,
or-
again, our standard would be whether or not they were manifestly erroneous. So even if I might have ruled differently, I would not overturn that opinion based upon that fact. We're going to have, the standard is that no reasonable person would have made the ruling that way, and they were clearly wrong at that point, and then that's when a change could come into effect.
Senator Mizell, you've hit exactly the difficulty in the trial court, especially if there were allegations of sexual abuse or something, but no one has verified that. It's not been substantiated by everybody, and there's no mental health professional that's going to come in and testify. So basically, what you're going to have is both sides bringing people saying totally different things. And that's, then the judge is in that horrible position, which I've been in, I'm sure Judge Landrieu's been in before, that you're going to have to choose one way or the other. And I would put in as many factors as I could to try to safeguard the child. I would make a review every month. I would, make them send me the report cards to make sure the child's still doing well in
Right.
school. I mean, as many factors as I could to try to make sure I made the right decision, because I was petrified myself that maybe I chose the wrong parent,
Right,
and I
right.
could have ruined this child's life by
Right.
choosing the wrong parent.
Golly, I appreciate
Yeah,
you think like that.
Yeah.
I appreciate.
It's-
But at that point, if you see nothing that really lends to believing the report, then are we back at square one where there's a 50-50? We're not where the person who had the question is lost.
I would think probably
That. Sure,
50-50,
right.
yeah, because that's
Okay.
our standard would be 50-50, so
Okay,
that would be where we are.
I wanted to make sure
Yeah.
that. Okay,
Yeah.
thank you.
Okay.
Madam Chair.
Thank you so much, Madam Chair. And again, we want to thank all of you for coming. I do want to challenge you, though, before you leave, because we need help, right? We are looking for a better path forward. We know that we have gaps. You guys have outlined some of those gaps, and we want y'all to help us define the answer and come up with a solution. Judge Belford, though, I do want to ask you if this is not against any prohibition or anything. I would like to know the number of judges in the family court system, because it seems like, so that is something that I'm so glad you asked that question, because we have the family court here
Right.
in Baton Rouge, but everybody else has a system, division, whatever you want to call it. I would like to know those judges, how many we have in the whole state total, and I'd like to know how many of them did beyond the mandatory training.
That's something I'm sure that we can get with the Supreme Court about. I know that Really, the easy answer is our district court judges, all of them have this jurisdiction with the exception of the 19th JDC, where those 15 judges do not have subject matter jurisdiction over family court matters. All the other district court judges throughout the state have concurrent jurisdiction over family court with, as we were indicating, some courts set up dedicated sections within their court that would hear it mostly, but not all. As Judge Holdridge indicated, they would rotate through and still have that general jurisdiction component. But I can get a more detailed answer from the Supreme Court that has that numbers and get them to you if that's what the task force would like.
I would like to see
Senator Barrow,
that.
I think all of the newer judgeships were not set up like the 19th because of the fact that it makes more judicial economy sense. Like in St. Tammany, I know, let's say both of the St. Tammany family court judges can't hear this case. Well, they can just go get one of the other district court judges there and they can go hear that family case because they all have subject matter jurisdiction to hear the case. See, in East Baton Rouge, if one of the 4 family court judges can't hear the case, they can't just go get one of the 19th judge. They couldn't go and get Judge Balfour and say, Judge Balfour, come hear this, custody case. He would say, no, I don't have any subject matter jurisdictions. So I think most of the newer judgeships are all, well, they designate a family court, but they all retain subject matter jurisdiction so they can hear any case. So any case, if that judge has to recuse himself or move him, that another judge can just come in and fill it out. I think that's my understanding of the newer courts that have designated family courts but have not actually done a family court like the 19th.
I just want to see the training level.
Yes, ma'am.
Understood.
Yeah. Okay. All right. Thank y'all so very much.
Thank
Have a
you.
great
Thank you,
day.
ma'am.
Thank you so
we
much.
appreciate you so very much.
Thank you.
Okay, now, guys, we do have some individuals here who would like to provide testimony. And so I'm just going to call them in this order. And if you're still in the audience, if you would please just come to the table. Chris Alexander, I don't.
Left.
Okay, I just said I don't see him.
Left, yeah.
Okay. Is this John Swisher? Right here. Okay, Mr. Swisher, come on up. Martha Huckabee. Kim Sport. Okay. Is Kim Sport?
She just stepped outside.
Kim Sport? Kim Sport or Richard Ducote?
I'm finished with this.
All right, and do you want to go first, Ms. Huckabee?
Yeah.
Ms. Huckabee, ladies first.
Okay, thank you so much. I appreciate actually listening to all the testimony from the judges because it's good for me to hear their perspective. Coming from someone who is actually being abused by the system, it's refreshing to hear that they do care about the system and that they stayed here that long, even though they needed to leave. So I would like to abolish family court completely and start over because I can't even see how it could be fixed. I'm not saying, I know that it's not every judge, but there's a particular handful of judges, and there are many cases where mothers are being stripped of their parental rights and the children are being allegedly familial trafficked by their fathers, and that's not being investigated at all. Instead, the judges are weaponizing their powers and they're dismissing the evidence, and there's plenty of evidence in these particular cases, and I can't even wrap my head around it. In January 30th of 2020, I was a court witness. I was in the courtroom and I witnessed a judge After 7 hours of deliberation, multiple counselors, doctors, physicians, all the evidence being presented before this judge, and from the mother's side, and the father's side had no witnesses, no evidence, nothing, I mean, zero. And at the end, the judge gave the bailiff his verdict, and he ended up ruling according to what the hearing officer had ruled prior. I think from like August 15th of 2019, that hearing officer had ruled in favor of the alleged abusers. So all the evidence that the mother was trying to present in that hearing was dismissed, all of it. And then by the time it got to the judge, the judicial judge, the court, the hearing, this mother had hired multiple attorneys. Every one of them, I don't know, it was strange. It was like after she'd hired them, they'd end up quitting. But one particular time, August 15th of 2019, I was there, and they were twins, these attorneys. And it was very strange because they were bickering back and forth with each other outside, and I thought it was odd. I'm like, why are they fighting like that? And they had a stack of paperwork, and they literally handed all of the mother her paperwork and said, I quit. And she's getting ready to walk into the courtroom. She needed them to represent her. And she literally almost fell out. I mean, I had to grab her. I said, what do you mean? How do you quit the moment you're about to go into the courtroom to represent her? And they said that the judge did not allow them to quit the 30 days prior when they submitted, they wanted to leave the case. So they tried to submit that 30 days. I don't know the proper terminology. So she was forced to go into that courtroom, and I watched her. The judge gave her two options. One, you hand your toddler over to the alleged traffickers, the alleged abusers, or two, you represent yourself. That was it. Now, she asked me, what should I do? And I said, I don't know, this is up to you. You're going to have to make that decision. She decided to represent herself. That's how bad this was. This is how, there's no way a mother in good faith would hand over her child, her toddler, her 3-year-old toddler, over to his alleged abusers. So she represented herself. It was terrible. It was a fiasco. So if you pull up those court records today, it's a fiasco. I'm telling you, it's terrible. And the alleged abuser, the fathers, their attorney, there was a video that was played, and it was a video of the child performing fellatio on the trunk of an elephant at 3 years old. The video undoubtedly shows that there's something very heinous going on here. Very, very bad. But the attorney of the alleged trafficker, the attorney of the father, said that the child was sucking a pacifier, and that's all that was. But if you watch the video, which these things we've sent to you, Senator Barrow, we've sent you everything. There are 3 cases. The other case is a woman who Netflix did a TV series on and said that she kidnapped her son and she quickly ran with her boy. Well, it just coincidentally, it's the same city, Kenner, Louisiana, same judges, same attorneys, same sheriff's office, and the same Dr. Klein, who actually reported on behalf of the baby. On both babies. So there are medical records showing that these children have been hurt and no one is doing anything to protect them. And the system has taken the children from the good parent and given the children to the alleged traffickers. So fast forward September 2020, I receive a defamation lawsuit. I'm being sued now by the alleged people, saying that I was calling them all kind of names and lots of false accusations in the lawsuit. So I'm about $150,000 into defending myself now, which is okay because by the grace of God, He's provided everything that I've needed. And you know what? I'm here today to tell you that there is a massive clandestine espionage corruption going on within the family court system that needs to be dismantled, or these children need to be examined. Now, I don't know. They've been with their alleged abusers for 5, this one little boy has been with them for 5 years now. And the mother's had 1 hour in a closed room, supervised. There's no evidence she hurt her son. She's the one who reported the abuse. Nothing against her. Nothing. And all the evidence against the alleged abusers was completely dismissed, including the video. And so, here it is, this second case that I feel the Lord brought to us is a replicate of this case. You have same judges, same attorneys, same sheriff's office, same Kenner police. You can actually lay it out, take both mamas. One mother chose to flee with her son, while the other mother chose to stay. Both live in Kenner. It's not a coincidence. I really believe the Lord ended up bringing this case to me so that I could see it and present it to you all. It's sad. Netflix did a TV series, an unsolved mystery on this one particular woman who chose to flee. And they called her a kidnapper. They didn't show any of the evidence I watched it the other day. I watched it twice already. They showed no evidence of that the mother produced, none. And Dr. Klein, he wrote out a good report on both boys. So we have, reports that there was something, but no one has ever taken the time out to protect the children. We have a PAC that says protect the children, and millions of dollars are funneled into this PAC. And this money is not being used, I don't think so, to protect the children when we have children that are, are not being protected here in the state of Louisiana. I don't know, there's another mother, she's a doctor, and her son also, a third one. This is in New Orleans.
Ms. Huckabee, don't call areas or names, or you did say a name, but just kind of refer to the issue and not
I pretty much tried to.
Yeah.
Except for when I, mentioned the good thing, right? So I'm not mentioning any of the people, but there are courts that aren't doing the right thing. And they are judges that are protecting these alleged familial, because they are familial to the children. And that's not being investigated. I know we've heard a lot about children being rescued in the last couple of years from, various situations. We saw that movie come out about children being rescued, but we have a big problem here in the state of Louisiana where children are being familial trafficked and the babies are being given to the alleged predators, and the parent that is good is losing his or her custody. And that needs to stop today. Those people who are taking the parental rights of a good mother or a good father, they need to be disbarred. They need to be removed off the seat. They cannot be a judge. They are not a good judge. You cannot be a good person if you are protecting people who are harming our children. Our children are the most important, precious thing we have, and they must be protected. Just a little bit about me and who I am. So again, my name's Martha Huckabee, and I served as the Republican leader in New Orleans and as a congressional delegate. I also advocate for children. I have fostered children, and I worked extensively to protect them. In 2014, I worked with community groups and the EPA to secure tighter restrictions on hydrogen sulfide emissions, ensuring children could breathe clean air. My advocacy has always been driven by faith and a commitment to justice. On August 28th, this one particular mother and her child came to seek help from me. In that moment, I've been actively involved in advocating for their safety on multiple occasions. I witnessed the 24 judicial courts, and I'm not going to name the judges, dismiss all of the evidence against this mother and the child. And despite serious allegations, because there were serious allegations. And I served as a court witness on January 30, 2020, observing firsthand these injustices. Following my advocacy, I was sued for defamation of character. 1 month after recusal laws, and this is the great part, I was sued 1 month after the recusal laws were changed right here in this building from 1 year, you had 1 year to file a recusal, to 1 month. So the lawyer that I hired, he had already filed several recusals, and so he knew in his mind he had a whole year to file it. So when I hired him, he filed it. You know how they wait to the end of the year to do something so he filed it. Well, the judge that was allotted to my case was the same judge that I witnessed that weaponized his powers. Now, how was that judge allotted my case when I witnessed him do what he did? It's unconstitutional. It shouldn't be. He should not be my judge. So I filed 3 recusals to have this judge removed, and he refuses to recuse himself. I've brought this to the Supreme Court already. And the judges in the Supreme Court, there were 7 of them. Two ruled in favor of me, but they say judges don't make laws. They rule according to the law. And since the law was redacted from 1 year to 1 month, 1 month before I was filed the defamation lawsuit, how convenient, I can't get a recusal, and this same judge rules over my case. So recently I filed a slap motion because I'm media. I work for WGSO 990 for about 5 years. It's independent journalism, right? I do radio broadcasting. This same judge ruled that I was not a radio broadcaster, that I was a podcaster. When you can Google my name and you can see that I'm a radio broadcaster. He literally lied. I mean, he said I wasn't what I was, and then he ruled that I pay $7,100 to the alleged person who's suing me for defamation of character. So my husband, being the people that we are, we pay our bills. I paid that debt. And right now, it just sits very silent. Nothing's being said, nothing's happening. They did ask me if I wanted to write a public statement to say that that individual isn't what I said he is, but I refuse to do that under principle. I cannot write a public statement and say that. When I know what I know, then I know. It would be against my everything. And so here I am today, just speaking before you all, letting you know that there is massive corruption. This pattern of corruption and protection of alleged familial traffickers is unacceptable. Similar concerns exist in other cases, including those involved in minor children. For example, that television show on Netflix raised accusations regarding a mother, and that's a public, that's on public. Can I say that because it's public? The TV show? The Unsolved Mystery? Can you do that because it's public or no? You don't want me to do that, do you? Okay, huh? Anyway, you can go to Unsolved Mysteries and you can see that, and they are accusing that lady of kidnapping her son. But they didn't tell in the film that the mother they had 7 counts of sodomy and sexual assault against that father. And that the DA or the DA dismissed the charges. That mother fled for 7.
It is or is not in the documentary?
He dismissed. There were 7 counts of sexual assault.
In the documentary?
No, they left that part out.
Oh, okay, that's what you say. They did
yes,
not.
Yes, they did not divulge that. Okay, there's an article about it, and it shows you the charge. So I pulled it off the article. Anyway, the DA dismissed the 7 counts. And so when you watch the film, you're led to believe that the mother just left with the child and that there wasn't a reason why she left with the child. And so these types of accusations have contributed to the incarceration of that mother. That mother is still in jail with $1 million bond. She's remarried, and her husband is also in jail in Colorado, so that's $2 million bond. And they're looking at being extradited back to Louisiana, but I don't know where that's at right now. And that's just pending. So, you know, we have an issue here, and I would really like for you all to look into this. And then the other case is this other mother who lives in New Orleans. She's a doctor, a pharmacist, and she also sent in some emails to you as well, and so did the other mother. So you have all of that in your email. And her son is the same situation where the judge stripped her of her parental rights and gave her toddler to his alleged trafficker, which is also a physician. And he's now fled to Texas with their son, and she's lost her parental rights. And I think she spent about a week in jail herself for kidnap charges. That's what's happening.
And I really want to thank you for your advocacy and your work that you have been doing throughout the years. This is not something that you just started doing. You've been doing this work for a long time. And being a voice for those who don't have a voice. And so I do want to thank you for that and for your testimony today. I felt really bad, and I didn't want to interrupt you once you started, because I was like, oh, I hate when we forget to do that, and then all of a sudden we start reading our disclosure that we are supposed to state during these hearings. But I do want to take the time to do it now before anybody else testify, because I personally don't like doing that. I think that's very rude when we forget to do it. But, you know, we welcome all the testimony here today, and I want to remind everyone not to identify a child victim or provide any public graphic details of any alleged abuse. We do not want testimony that defames or disparages individuals' names who are parties to litigations, are members of the judiciary, DCSF, etc. We have stated this repeatedly that, you know, we are not triers of the law, of facts. But we are here as policymakers to be able to get the information and be able to change the law so that we can change how it is being enforced. And so, again, we thank you. I want to let you know how much I appreciate you. I thank you for sitting here all day, all morning. And hearing our judges as well. And as you can see, we do have our work cut out for us. And as we are looking for solutions to address these gaping holes in the law, I do solicit your help and support as well.
Thank you. I respectfully urge this committee to investigate these matters and ensure accountability and enact measures to prevent judicial corruption and the endangerment of children. I appreciate y'all. Thank you so much for what you're doing.
Thank you so much. Mr. Let me see. I'm sorry. Swisher.
Yes, ma'am. Yes, ma'am, Ms. Senator. Describe myself.
Yes, introduce yourself to everybody, please.
My name's John Swisher from Lutcher. 35 years experience in automotive business until 2015, when my father unfortunately passed away and my family forced me to close it down. And since 2021, I've been a weekly talk show host. That's how I met Martha. And she is correct. I am the witness. The judge would not said that she was a podcaster when she was actually a radio talk show host, and they would not let me defend her. They would not let me vouch for her.
Okay.
Everything she says, 110% true.
I believe you. Is there anything else you would like to add?
You good?
I'm good. This is personal to me.
Okay.
I was in boarding school when I was from ages 6 to 10 years old, born in Beaumont, Texas, and I was molested by pedophile male dorm counselors. So I know exactly how them young boys feel.
Sorry about that.
They got their justice coming.
That is so true, and now you are able to be a defender for others,
That's right.
and we appreciate that. Okay, Mr. Swisher and Mr. Ducote.
Yes. Good afternoon, members of the committee. My name is Richard Ducote. I'm an attorney from Covington. I've been before this committee a number of times. I've devoted 50 years of my life to the protection of abused women and kids, 47 years as an attorney, 3 years as a probation officer in the Jefferson Parish Juvenile Court. I've been involved in writing over 25 pieces of legislation. Over the years, Senator Barrow and I and Kim Sport and Professor Getty in 2018 rewrote the Article 134 best interest factors to make the protection of kids the #1 priority. I've started the first program in the state to provide attorneys for kids in child abuse cases. I've done these cases that we're talking about, where custody cases involving child abuse and domestic violence in 46 states and in over 50 courts in Louisiana. And I was a special assistant DA in 19 parishes and was tasked by DCFS, then DHHR, with freeing kids from foster care and reforming the foster care system. So I have a lot to bring to this issue. First of all, I want to deal with a couple of real specific things. The issue about kids having attorneys in family court cases and custody cases, that has been the law in Louisiana for a number of years. Revised statute Title IX 345 says the courts have to appoint attorneys for kids in cases where there are allegations of child sexual abuse or where the cases are especially contested, or if the child's interests conflict with one or both of the parents. That is the law, and that's done throughout the state. It's really not a funding issue. Most of the courts have programs set up to provide attorneys. They appoint attorneys. The judges can appoint members of the bar, and typically do. The courts have the authority to appoint attorneys, as Judge Holdridge talked about, as a favor to the court and without pay. So it's just a matter of the judges doing it or not doing it. I don't think it's a big funding issue. Second of all, the question that Senator Mizell asked about kids testifying, and that's a real interesting problem, because, and I'm going to talk about the difference between family court proceedings and all the other courts. So if you have a civil court and you have a lawsuit, the judge or the jury's job is to determine facts. Who ran the red light? Who made the wrong turn? Who didn't mop up the floor in the store? It's a factual question. If you go to criminal court and somebody's charged with a crime, the question is, did that person commit the crime beyond a reasonable doubt? And it's a factual question. If you go to juvenile court, the question is, was that child abused or neglected? It's a factual question. Family courts, in the cases we're talking about, are supposed to make factual determinations. Did this abuse occur? Did this neglect occur? And what has gone awry is the ability or the culture of the family court judges of the family court bar to make accurate fact-finding. And that's what I'm going to talk about. The issue of kids testifying, if a child is abused by a stranger or a parent, and that stranger or parent is prosecuted, that child testifies in court, unless it can be done sometimes through the Child Advocacy Forensic Abuse. But kids can take the stand and testify before the jury, and people can be convicted based on kids' testimony. The jurisprudence, the case law, has allowed kids as young as 5 to testify in criminal court in juries and sustain convictions. So, and kids can do that. The studies show that it's very empowering, and I've been in situations where kids are testifying from the witness stand. It's very empowering for them to be able to tell their truth and tell the story and be protected. So we have a situation in family court where we think, well, kids, we don't want kids to testify in family court. Well, so consequently, and you're asking the question, do the judges get the facts? What if the kids don't testify? But the kids are the victims. The kids are witnesses. So to, in advance, preclude the kids from testifying automatically removes from the court some of the most powerful factual testimony. So it's a very unfortunate notion that the courts have acted upon. We do have what's called a Watermeyer hearing. I don't know if you're familiar with that. That case comes from a case, Watermeyer versus Watermeyer, which was a Louisiana Fifth Circuit Court of Appeal case some years back. And that allows for judges to have kids come into chambers and be interviewed. And, and the attorneys write questions for the judge, et cetera, and the judges talk to the kids. But it's not, it bewilders me in cases where the issue is abuse. A lot of times the judges don't want to ask the kids about the abuse, don't want to ask the kids about the facts. So what we've done is we've allowed a system to progress that is antithetical or automatically precludes accurate fact-finding under the guise of trying to protect the child. But what we do is we fail to protect the child because we're pretending to protect the child by not letting them testify. So it's a very bizarre situation, and I'll tell you what we tried to do last year with that. Okay, so last year we had legislation that would have said kids can testify in court, and we set it up, and we worked with Judge Oglesby, we worked with this committee, we worked Representative Egan. We had legislation that set up parameters for kids to testify in these cases factually, where they could be asked questions and there were safeguards built in, et cetera, and it would have solved that problem. But it didn't pass because the judges opposed it at the end of the day. So we also had, and you heard Judge Holdridge talk about it, and I went out and we had a nice conversation, and I'm happy to report that we're going to be able to fix this. Judge Holdridge complained and said he had been doing so for years, as have I, about the relaxed rules of evidence in family court cases. So what he's referring to is Code of Evidence 1101B2, which says that the rules of evidence that apply in any other civil case only apply in child custody cases to the extent that they tend to promote the purpose of the proceeding. And Judge Holdridge, who was a judge for years on the appellate bench, says, I don't know what that means. What does that mean? And I've been saying that too. What does this mean? Well, what it means, unfortunately, is the practice of a lot of judges has been, if the evidence supports what the judge wants to do, it's let in. If the evidence sort of contradicts what the judge wants to do, it doesn't come in under the guise of the relaxed standard of evidence under 1101B2. Only one other state in the country has anything similar to that, and that's the state of Utah, and it's not that broad. Last year, we had a fix for that. We came to court, to legislature, and we had a bill that fixed that and said, in cases where there are allegations of specific parental conduct that's contrary to the best interests of the children, 1101B2 doesn't apply and the rules of evidence apply. That bill was again introduced by Representative Egan. It was very well received. At the end of the day, the judges opposed it. Now, what I did get from Judge Holdridge, I believe, outside the hall, is a commitment that I think we understand what the opposition was, and we can fix that. That is the single most important thing this committee can do, is restrict the evidence, because the rules of evidence are put into place so that only reliable evidence comes in, and that is what allows the courts to make accurate factual determinations. Because if decisions are based on facts that are mistakenly determined, then the whole thing falls apart. So the other thing, that Judge Holdridge talked about too, which is absolutely true, is this issue about the appeals from the custody cases. Now, Judge Holdridge also talked about the emergency ex parte proceedings that can be done. I think Ms. Wescombe had asked about that, and that's under Code of Civil Procedure 3945. And that's a procedure where, in an emergency situation, you can get an ex parte hearing, and then you can get a ruling, a trial within 30 days. However, and this is a real problem, I'm involved in a case now with Casey Robury, who's been before this committee many times, and the Supreme Court denied writs on this last night. It kept me awake for hours when I saw that email. So in her case, there was a 6-day trial, 3945, under 3945, a 6-day trial, lots of evidence. And as a result of that has been in place where she's been on supervised visitation for almost 3 years now. Very expensive, doesn't have custody of her kids, hasn't seen her kids since May. We can't get the appellate court to hear it because it's still an interim order, it's not a final decree. And that's exactly what Judge Holdridge was talking about, and we talked about that in the hall, and we're going to bring this committee a bill to fix that. So there are a number of things that can be done. Finally, judicial education, and I was so happy to hear about that. So last legislative session, again, Representative Egan, I worked on legislation with Kim Sport, with the Tulane Domestic Violence Clinic for mandatory judicial education. Now, what do we need education on? And you hear this all the time, and I do want to get a copy of the survey. So what happens is we go to court and we have evidence of child sexual abuse, and Dr. Hook mentioned this. And the kids have made disclosures, the kids are acting out sexually. The father might have a history of domestic violence, which is very often coincides with the sexual abuse. And the judges say, well, there's no medical evidence. Or sometimes DCFS says, well, there's no medical evidence, so we can't substantiate it. And what's so frustrating is decades and decades and decades of studies, tons of reported appellate decisions have shown that the vast majority of child sexual abuse cases, even with penetration of young kids, young girls, young boys, oral sex, insertion of objects, all the stuff we're talking about, there is no medical evidence. Because, and there's actually literature that's out there available to people who sexually abuse children that tells them how to molest kids without leaving physical evidence. Because if you leave physical evidence, you're going to get caught and you're going to get convicted. So they know how to do it. And kids, and the kids, they entice the kids, and everybody's wired with sexually for there to be pleasure in some things. Some kids are stimulated to pleasurable results, and that's part of how the people get access to their cooperation in the grooming. So they do it in a way that doesn't leave physical evidence, or the physical evidence heals quickly, because just like if you get an injury to your mouth, it heals quickly. Same thing with genital tissue, same thing with rectal tissue, because it just, that mucous tissue heals quickly. So the fact that there's no medical evidence is of no consequence whatsoever, but I have heard for years family court judges reject evidence of domestic violence, of child sexual abuse that is supported by disclosures and sexualized behavior because there's no medical evidence. We also hear from judges, well, if she was really a victim of domestic violence, she wouldn't have stayed, she would have left, or she wouldn't have vacated and done away with the protective order she got, or she wouldn't have taken him back, and all this kind of stuff. That's elementary. That's anybody who does domestic violence work knows that that's the pattern. And very often women stay solely because these guys tell them, if you leave, I'm going to take the kids, or I'm going to kill the kids, or I'm going to do this. Or they you know, they're very good at the honeymoon phase coming back and everything else and keeping them in. But these are the things judges need to be taught. They need to be taught the dynamics. They need to hear from victims. They need to hear from victims of sexual abuse. They need to hear from the medical experts and the psychologists who work with the victims and work with the perpetrators. Because if you don't understand how this works, then you're not going to appreciate the evidence. And when the guy comes in and he looks calm, cool, and collected, and the mom is very frazzled and upset because her kid has been sexually abused, and the judge says, well, look, he looks fine and she looks crazy. Nothing, you know, nothing to see here. It didn't happen. And that happens over and over and over and over and over. So last year, we had a bill that would have required very extensive judicial education involving all these entities, the hospitals, the law school, domestic violence programs, et cetera. The day it was going to be heard by the committee, the Supreme Court sent a letter to, and it was Judiciary A, saying, look, we see this bill. We pledge, we're going to have judicial education. There's a separation of powers. You know, we really don't think it's right for you all to try to tell the court how to administer itself. We promise we will work and set up this program ourselves. We were all excited. Immediately, we had very good conversations with Justice Crane, who was involved. We had the judicial administrator of the Supreme Court. We had people from the Judicial College. We had some conference calls, and we're making progress. Then it evaporated. And a couple of months ago, the Supreme Court issued a new rule saying we're going to have 1 hour every other year for judges on trauma-informed. Okay, that's great, but that's a drop in the ocean of what needs to be done. So, and again, the whole thing about cost, it's not a problem of cost. You know, lawyers, and it's not a problem of time. You know, lawyers take a lot of CLE classes. We have to do it online. There's something that flashes on the screen that we have to respond to, so they know we can that's documented that we're actually involved and we're not off playing pickleball while the screen is running. You know, so there are ways to do it. The National Council of Juvenile and Family Court Judges has all the material that the judges would need for, and you heard Judge Balfour talk about these bench cards and bench books and things. The National Council of Juvenile and Family Court Judges has all this free. It's online, and that can be printed out and distributed to judges. There's a lot of literature. I have probably the most extensive library in the state on domestic violence and child abuse and child sexual abuse. I've offered to make that all available. You know, we've got tons of materials. It's just a matter of committing it and doing it. It's really not a matter of cost. So that's a crucial aspect. So I'm happy to say I think, based on the testimony that was presented today, we're going to get some legislation with Judge Holdridge's cooperation and assistance and the Law Institute. 2 more points. Last year, working with the Law Institute, we developed and amended, and that was as a result of 3 legislative resolutions that wanted the Law Institute to investigate the problems with child custody evaluators. One of the biggest obstacles to the protection of women and kids in child custody cases has been child custody evaluators. They've been misused. It's well documented, study after study after study, that the typical child custody evaluation is unreliable. It can't predict what's in the best interest of the kids. So with the Law Institute and the legislature, we enacted restrictions on what child custody evaluators can testify to, what mental health evaluators can testify to. So that was a big help as well. So, you know, and again, if we can change the rules of evidence and make those apply just as they would in any other case. And again, I think the committee spent a lot of time on this whole question about what happens with DCFS information. And Senator Barrow, you point out absolutely correct. carefully as other members of this committee did, and that is when the judges find out that DCFS didn't substantiate, then they don't believe it happened and they don't listen to the evidence that it did. And that's a real problem. That's why, again, we had legislation last session to remove any consideration whatsoever in child custody cases from DCFS findings or from law enforcement findings. Because just as if you had an automobile accident case, you wouldn't just go to the police and say, well, who do you think ran the red light? You know, or get some agency to come and tell the judge whether the accident, whose fault it was. You know, and again, Judge Holdridge had mentioned this thing about who's telling the truth. It is totally inadmissible for any expert to opine on credibility. That's the judge's job. So if we can tighten up the process and make family court proceedings work like any other court and require them to make factual determinations that are relevant to the best interest factors and to box that in with the rules of evidence, then we solve 90% of the problem. One more thing about cost. Under the Post-Separation Family Violence Relief Act, which is Title 9, 361 and 367, the abusers pay all the cost, all the attorney's fees, all the mental health fees, all the attorney's fees for the child and everything else. So there are provisions there. We need to enforce them. We need to tighten up a few things. And this committee, if that is accomplished, will have done a terrific job. I want to close with one thing. When I was passing the steps to come around to the building, I saw something that I remembered seeing many times. And probably many of you don't know this, but the cornerstone of this Capitol, which is the tallest Capitol in the country, the cornerstone says, "We live for those we love." That's it. It doesn't say "e pluribus unum" or some other Latin phrase for some great. It's a very basic rule of life. We live for those we love, and that's what all the people who keep coming to you, asking for your help, and who sacrifice so much for their kids in very, very desperate situations, and get so frustrated and so beaten down and just denigrated for trying to protect their kids. That's all they're trying to do. So thank you very much.
Thank you so very much. And I didn't want to interrupt you while you were speaking, so I have like a set of questions that I want to ask you really quickly. The appointment, when we talked about child representation and appointments, which the law already allows us to do,
Yeah.
So do you think that is actually happening? It appears to me that it's not, but I mean, is it happening? Do you believe that it's happening in most cases?
It varies from state to state, parish to parish, and it varies whether or not somebody requests it or points it out to the judge. Some judges do it automatically.
So do you think that's a rural urban or rural city issue, more or less, or just the lack of knowledge thereof? Or?
I think it's individual judges
Okay.
for the most part, but it's in the law and it's very clear.
Okay, and there is a way for this already to be compensated. So this is something that I really want to delve into a little bit more, make sure that we have all of the information and understanding what some may be saying are barriers or whatever is being stated, so that we can address that, because it's already there.
So, for example, a lot of the courts will appoint the legal aid. Like Southeastern Legal Services has a very large staff of attorneys. Loyola Law Clinic is often appointed in Orleans and Jefferson to represent kids in cases. And it's not, and thankfully, it's not a guardian ad litem program where somebody just comes in and tells the judge what they think is in the best interest of the kids, which they're unqualified to do. It's to advocate for what the kids want, and there's nothing really wrong with that. They can, the rule 9345 says if the attorney is able to present evidence to the court that might not be presented to the court otherwise, that's one of the grounds. If the case is especially protracted and complex, that's one of the grounds. If the child might have a conflict with one or both of the parents. So, and I've seen this, and it's really, it's remarkable to see where you have a judge, and I've been in situations where judges are absolutely, seem to have set in their head what they think is going on, and this whole thing about coaching and all this other stuff, it's so distressing to think that judges go into these situations with almost a default position that these are just some parents who are making stuff up and fighting, and the kids, you can't believe them, and all this kind of stuff. That's such a hard place for kids to start in these cases. But the attorney can go and present the child to the court in chambers, present their testimony, and when it's done properly, you'll see the judges, it's like Eureka. I understand what's happening. It is what everybody has said because the kids are talking. It's real simple. It's just like when kids get on a jury and they testify in front of a jury and describe what happened. It's like everything else. They're human beings, and to think that they're automatically just pawns who, are saying stuff because somebody told them to say it. And I mean, kids don't describe these graphic acts of digital penetration or fellatio based on coaching.
I would agree with you.
And one of the things that Judge Holdridge, Dean Landry talked about was if a child is asked, what did your parent tell you to do when you came in here? The child says to tell the truth. They go, oh, yeah, well, we can't believe the child. Yeah, they were told to tell the truth, wink, wink, wink. If that's how we're operating our courts, I don't know. I give up. Or I don't give up. But
No, don't give up. Don't give up. But I understand what you're saying. Kind of going back to, you kind of pointed to some legislation because somebody asked me, did I bring the legislation? And I was like, no. So which piece of legislation did you bring in or that was coming before us? Was it something that Egan had found? Because I was like, I said, he dropped me. I'm no longer his,
What's that?
No, you dropped me. I'm no longer your legislator. No, I'm just kidding.
No. We worked with a lot of legislation.
Yeah.
But he had the one on the judicial education. He and Representative I think maybe okay.
It was the one in the House or the Senate? Because you say
House bills.
Okay, they were House. So did you say?
Kemp Carver had one of the, he was a co-sponsor. Yeah, we had.
Okay.
Yeah, so
Jude A.
when it came over.
Yeah, Judy. Oh,
yeah,
so it came out the House.
Yes. Yeah.
Okay, made it to
So
the
we
Senate.
tried.
And when y'all got to the Senate, it's when the judges.
We had a couple of bills. We had a whole package of the bills that were addressed to exactly the things we're talking about today.
Mm-hmm.
Some of them came, yeah, that's right, Dixon McMakin. Right.
Okay.
So we had some bills that came out of the Law Institute.
Gotcha.
That dealt with some of this.
Okay.
And we had two bills and we combined them to come out to the one. I think that was the 9331 and 331.3 that dealt with the mental health evaluations and custody evaluation. So there were a number of, but all the issues that were talked about today by Judge Holdridge were part of some of the legislation that was introduced last session. So I think we're going to be able to get that all resolved, and we'll bring it all to you, Senator Barrow.
So the legislation that you guys had for the education, which they asked you not to bring, right? And they say, we're going to take care of it, we're going to address it. They're taking care of it was the 1 hour every other year?
That's correct. Yeah, and so we started off great. I mean, we had this whole thing going. We were on the phone and setting up these meetings, and then it just kind of fizzled out. And so
1 hour.
1 hour every other year, and it's trauma informed, which is great, but there are real specific things about the dynamics of domestic violence, child abuse, child sexual abuse, the ways to look at it. If you don't understand the mentality of abusers and the mentality of the victims, then things that are paradoxical will convince you things didn't happen, but it just is, I mean, I had a case years ago up in Shreveport where the same court gave two conflicting reasons for doing the same thing and not protecting a child, and I took them both up to the appellate court, and the appellate court affirmed based on two conflicting views. But it was cognitive dissonance. Well, we want to believe this, so we'll disregard evidence to the contrary. So it's
Well, we
frustrating.
still have work to do as it relates to the training. That 1 hour every other year certainly is not satisfactory for me. And I like the fact that you guys did talk about the evidence, code of evidence, us really addressing what that looks like. And so hopefully going forward, we are able to come together to really work on what that looks like. That was troubling for me to hear that in terms of how those decisions are being made. Without that level of concreteness. So, or a continuity, maybe might be a better word. So again, I do want to thank each of you for being here. It takes a lot of courage to come before the legislature to speak and to tell your truth, and to make sure that your voice is heard. And I've seen you before, Ms. Huckabee, but I've never seen you, Mr. Swisham. So I want to thank you for being here today and thanking you for adding your voice.
It was an honor and a pleasure.
Well, thank you so
It
very
was
much.
an honor and pleasure.
Thank you for being here, and thank you, Mr. Dakota, as well. So I look forward to continuing to work with you.
So if it's okay with me, what I'd like to do is to get with Judge Holdridge, get the legislation, I can dust it off from past years and kind of fix it up, polish it up, and then get it to you for
Oh, absolutely.
committee for consideration.
After next month, I will be definitely putting together what the packet is going to look like for the upcoming legislative session. I will begin to start putting together these pieces of all the things that we've been discussing over the last couple of months so that we can have a legislative packet.
Thanks to all of you.
Thank you.
Thank y'all so much.
All right. Thank you so very much. And last but not least, Ms. Kim Sports.
Hi.
How you doing?
Hello.
Hello. Good to see you.
I've heard my name being mentioned here. I wasn't expecting that. My name is Kim Sport. I'm an attorney. I'm on emeritus status because I'm old. And I haven't been to the Capitol in the last few years because I'm telling you, sometimes coming here can just steal your soul. It's a difficult place to be in. But
well, we are glad to see you.
thank you.
And
Thank
nothing
you.
get old but clothes.
Okay. And let me begin by saying, Senator Barrow, you've been a champion. You've been, you are at the helm of every committee which affects victims of abuse in the state of Louisiana. And I was going to say women and children, but really, let's recognize that men can also be abused and that women can be abusers. I am the immediate past chair of the Louisiana Commission to Prevent Domestic Abuse. That commission was created in 2014 after a flurry of legislation was unanimously passed to bring more attention to the issues of domestic abuse in the state of Louisiana, particularly the high homicide rate that we have. We were in the top 10 for domestic abuse homicides for as long as anybody has been counting. That year, our focus on homicides broadened, and we actually passed legislation which affected the Code of Evidence, the Civil Code, Criminal Code. I mean, it affected firearms, it affected who can get a divorce and when, and everything else. And as I've been even though I haven't been here in person, I've been watching these hearings, and I've noticed that there have been some comments made about how some of that legislation from 2014 and also 2015 has perhaps been abused by litigants in divorces, by attorneys, and whatever. Some people are calling it the silver bullet in divorce cases and also in child custody cases, that as a last resort, try to get a protective order against your spouse, because then you can get an immediate divorce, right? You can, you're more likely to have primary custody because of laws like the one Richard passed, Post-Separation Family Violence Relief Act, what you carried for us in 2018, dealing with the Article 134 child custody factors. And earlier, someone was asking, well, what is the primary thing that judges are supposed to consider? Thanks to Richard and Professor Michelle Getty, the primary factor for consideration in a child custody case is the potential for that child to be abused. It is number one, and we have to keep that in mind. And that's so pertinent to what we're hearing here. But the other things that flow from getting a protective order, loss of firearms for the duration of the protective order, child support can be in excess of 2/3 of the net income of the abuser. The abuser is going to have to pay all of the costs, including costs of appeal going forward, mental health evaluations and everything else. And I hate when I hear that someone is abusing a law that we tried so hard to pass strictly to protect victims of abuse, women, men, and children in these relationships. So I wanted you to also consider that sometimes when people come before you, and as is the case in a lot of circumstances, it's those who have been ruled adversely against in a court, disgruntled employees in other venues, and other committees and things like that. And because this is not a courtroom, any person can come here, give their name, say, I have been a victim of corruption. I've been a victim of judges that, are doing the most horrible things in the world to me. I haven't seen my children in 2 years. I'm going to jail because I have to pay my husband's legal fees. I just want to caution you that sometimes that person, that victim sitting before you, might be a wolf in sheep's clothing. I heard that Senate Resolution 81 had been passed in 2024, and I know that is a big topic of discussion in the family court world right now. That resolution, which asked the Louisiana Supreme Court to study the East Baton Rouge Family Court, passed from start to finish in 8 minutes. 8 minutes. 3 people testified, and I'm not going to name them, because we're not going to name names, right?
No, ma'am.
But let me just tell you a little bit about their backgrounds. First of all, one said that There's no transparency in the courts. I thought I was in North Korea or China at the time. It's absolutely insane. It's a nightmare. Family courts ought to be shut down. Well, this particular person was permanently enjoined from coming near her parents or going to their home, wherever they may be found, calling, bothering, texting, or harassing them in any way, because their daughter exhibited bizarre behavior and assaulted and battered her physician father. That's one of the people who said the family court was corrupt, insane, like, North Korea. The next person that testified said that her case, even though she didn't have a real family court case at the time, was being investigated by this plethora of agencies and named all these, all these different acronyms. I'd looked them up, I couldn't find any agency that was associated with them. But this person had lost custody of her children, citing her history of substance abuse, failure to take advantage of treatment programs, credible testimony about the mother's inattentiveness to her children. And amazingly, this person had a 3-page rap sheet that we found, and recently spent 4 months in jail, and actually was charged with another crime for which she went to jail, 13 days after she testified before the committee in that 8-minute hearing. The third person who testified, the last person who testified, has been all over the media. You've heard from her. I'm not going to say her name. And she has been filmed outside of a jail, reporting to jail, like so many hours every Saturday or so, for contempt of court, failure to pay child support, because she was found to be a perpetrator of abuse under the Post-Separation Family Violence Relief Act, and had received a protective order was issued against her under the Domestic Abuse Assistance Act. So yes, the charges were assessed against her, and she never paid them. And in this case, the mother was found to have placed one of her children in a chokehold, to have hit her children in the face, to have called them unspeakable names that no child should be called, and on and on and on. So these 3 women came before a committee, and a resolution was passed based on that testimony, asking the Louisiana Supreme Court to look into the East Baton Rouge Family Court, so that to make sure that there's consistency in judgments and fairness and transparency and all of this kind of stuff. And since that happened, total havoc has been wreaked in East Baton Rouge Family Court. A supernumerary judge was appointed by the Louisiana Supreme Court with a lot of authority to conduct a study. I know that you've asked for a report of that supernumerary appointment. I don't think that anybody has received it. But the situation got so out of hand because, how can I explain this? That supernumerary judge actually inserted himself into cases based on who really complained the most to the legislature, even though those cases had no pending child custody or visitation issues, even though the parent who did not have visitation had not filed any pleadings, just went in, reopened the cases, which caused a lot of not only mental anguish to the children and the abused parent, to the abused children and parent involved, but also enormous costs, tens of thousands and thousands of dollars. More troubling in these cases is that a sitting Louisiana Supreme Court justice appeared in hearings in the East Baton Rouge Family Court for one of the women who testified before in that 8-minute hearing and spoke on the record. That's unheard of. That's absolutely unheard of. And it's also true that certain legislators have also appeared in court and have spoken to the supernumerary judge who inserted himself into these particular cases on behalf of the women who testified in the legislature. Now, if that is not outright unethical, it certainly creates an appearance of impropriety. So I know you all know what's going on. I hope that it gets fixed. I hope that so many things get fixed regarding domestic abuse and sexual assault and all the other things that happened. You know, Dean Landrieu was sitting here, and I remember her sister. I remember U.S. Senator Mary Landrieu, and she spoke about a cup, like a child is a cup of water filled to the very, very brim of the cup. And it's peaceful and it's calm. And that what we allow to happen to children through abusive situations is that water gets rough, the drops start falling out of the cup. And that's such a great analogy for what really happens to a child who is just perfect in every way. And yet we let outside forces, abusive circumstances just destroy those precious lives. I agree with, and also I just want to say ditto to everything that Richard Ducote says. I have more respect for this man than you can imagine, because Richard will tell you more than anybody else, his job is not to go to court to make a judge happy with him. His job is to go in there and advocate for the safety of the people that he represents, particularly the children. And let me talk about the how there's a family court and there's a criminal, you know, and we have multi-jurisdiction courts. I personally feel that family courts are great because the amount of education that one needs to have in order to deal every single day with family court matters is massive. You've got to pray for people that practice family law, and you particularly have to pray for judges who choose to specialize in juvenile and family court proceedings. It's the toughest thing on earth, and their decisions matter more than I think any case regarding a civil proceeding, whether it's the Toyota things that Madeline was talking about or whatever, because we're talking about a decision that's going to impact the life of a child. And I agree, in a perfect world, a child is going to be nurtured and loved by two parents, okay? And I don't want to be politically incorrect by saying two parents, but every child needs to be nurtured and loved, and it doesn't happen. I know that in some states, in order to try to make these cases take care of themselves faster, maybe you shouldn't be able to get a divorce until you get all these other matters taken care of. Think about it. That will bring people to the table, because usually one divorcing party wants to move on with their life. But a lot of times the divorce is granted, Then you've got years of child custody proceedings, child support, spousal support proceedings, and then community property partition. It goes on forever. But what if you couldn't get a divorce until you got all that taken care of? I know that's never going to happen, but it's a nice thing to think about.
It would speed up the process.
Yes, it would. Would it ever? Would it ever? And then Richard also mentioned the legislation that we've worked on, the 1 hour, one mandatory hour every other year on trauma-based care or trauma-based litigation in the courts. Well, the fall judges conference just took place in New Orleans, and it was on the agenda. There was a domestic violence course on the agenda, and it was going to be taught by a sitting a sitting judge in a family, a designated spot in the civil district court, and then also by a representative from LPOR, the Louisiana Protective Order Registry. Well, let me tell you, it said, and this will count for your one mandatory hour. And I sent it to Richard, and I said, what the heck? What the heck? Where's the mental health professional in this? What does LPOR have to do with that? The judge who is teaching this is one of the ones that needs this trauma-informed training. Mm-hmm. So judges need to know that even though they like to be by themselves together so that they can speak freely about their cases and the problems and everything, judges like to be taught by other judges, right? And I just think that there are situations such as in the complex area of domestic abuse and sexual abuse, family violence and whatever, that judges don't have the answers to teach to other judges. And we need professionals like all of you in this room teaching judges. And then there was one other thing. Let me just think of it real quick. It's hard when you're just sitting there and you're listening to everything. I don't know. Does anybody have any questions for me? I've worked on so much legislation.
Questions here, but I do want to speak to some of the things that you've spoke to.
Yes.
So first of all, I just want to thank you again for being here. Certainly, we have worked together on a lot of issues throughout the years, and I want to thank you. And oh my God, her name just left my mind, just like that.
Charmaine.
Yeah.
You forgot Charmaine?
Can she hear me?
Charmaine Cassiope. She's like Sherry. Just call her Charmaine.
I know her very well. I want to thank y'all for the great work you've done throughout the years. I do want to go back to something. I wanted to get the card to read that individuals have to fill out when they come and testify. And then going back to what I read after the second public testimony. The first public testimony, which I should have read before, that we are not triers of fact. We are not triers of fact. We are here to receive and hear information, so we cannot control what is stated to us. Everybody that signs this card, there are 4 things on the back that it speaks to: committee rules, amendments, handouts, and then oath of witness. And so when a person come and fill out this card, they swear that they are telling us the truth, right? So this is the information that we are given, that we go by. We cannot control any of those factors. I will say personally, I have not been engaged with any judge in terms of anything that is prohibitive as it relates to speaking to them about any particular case. And there is nothing, I think, that prohibits any of us from going to court to sit in to hear, because we are trying to better understand procedurally what is happening and how it's happening. I will say this: I know that many of the things that you referenced were from the 19th JDC from East Baton Rouge Parish, but I can tell you I have heard about cases from across the state, from the top to the bottom. None of them are coordinated or connected in any way, other than some of the information is very similar. So in my opinion, there is something wrong there is something broken, and there's something that has to be fixed. If turning over the apricot gets it fixed, then guess what? I'm willing to turn over the apricot to get it fixed. You stated it. Almost everybody come to the table stated the same thing about our children. And we agree upon this in terms of who they are and how they come into the world. Innocent, fragile, dependent upon the adults that are in their lives. And when those adults fail them, then it's incumbent upon other adults, like the adults here, to step up to the plate to ensure that they are safe. So, as I listened to what was being said, I think I'm trying to understand. There may have been some things that, I don't know, seem like some cases, some pending things. And as you were stating those cases, that some of them have actually gotten new charges on, I wonder if they're connected to their suit, right? I wonder if, or is it something completely separate? And I'm not getting into that because that's not my job. My job is to figure out where the parts of this law is broken, where we are failing kids, and why, and how do we fix it. And I think Senator Mizell said it best, where, when we look at that, we are 49th by Casey. How do we get better? And we can't keep doing the same thing, expecting different results. We cannot. We cannot. It doesn't work. And so, if that's what it takes to get to the end result, where we are addressing where the shortfalls are in addressing the needs of kids and addressing these gaps, like you that was very clear and very gaping and concerning. The 1 hour, that's every other year. That you kind of lost me because when you said that they say, oh, this can serve in lieu of. I didn't hear anything else after then, right? Because I'm going like, see, that's the kind of stuff right there that really makes me mad. I'm not going to say the word that I really wanted to use. But that's the kind of stuff right there. That right there.
Yeah.
Okay?
Yeah.
So we can't have that anymore. I'm really, really, really tired of that.
Me too.
Yeah, I am. So I'm looking for true answers, true resolve, and we're going to push until we get there. And so next month, I forgot who's next month. I know that we are bringing IT. I know for sure. Law enforcement in schools and IT. So that's who's going to be at our next hearing. And after the end, then I'm going to start putting all this together, and we're going to bring everybody together, because I am looking for true answers, true solutions. I don't want no fictitious, what we think may work. I want us to use science-based, proven methods that are working in other states. It can be done. It needs to be done. We have to get it done. Yeah, yeah.
And I think that we also agree, Senator Barrow, that someone who brings a false allegation of sexual abuse or family violence or domestic abuse hurts everybody, because it just harms the entire system. And I want to, if someone is falsely alleging abuse, I want to see the book thrown at them. And, we have things, unlike a lot of, usually someone can go and report a crime and say, oh, I was battered or whatever, or you file a lawsuit against somebody because you were injured in a battery against a stranger. Okay, yes, you have to prove your case in court, but we always add something when it's an allegation of domestic abuse, because remember, we have exemplary damages now. And we always add a little extra thing as though there's some underlying sentiment that maybe the person alleging abuse isn't telling the truth. And it's always that if this is frivolous, then this, and this is going to happen. And you don't see that in any other area of the law. But I do believe that if someone is falsely alleging abuse, it hurts everything that we've tried to do in this building, particularly since 2023. Since 2013.
Mm-hmm.
And it doesn't help anybody. So I just want to make sure that the the people who should be getting help and assistance are the ones getting it, and the ones who are making false accusations are called out. And I think that changing the evidence rules in family courts is going to be a huge step in that direction. And Richard, I'll work with you on anything.
Great, thanks. If I could make one other point, I meant to make.
Let me
before.
get Representative Edmiston, and then I hold your comment.
Chair, thank you, Richard. Just real quickly. Ms. Kim, I didn't catch your last name. I'm sorry.
Oh, Sport, S-P-O-R-T.
Yeah. I just want to, I'm sure you're aware that I'm the co-author on Senate Resolution 81.
Yes.
And I'm one of
yes.
the ones that you mentioned that have been in court a couple of times. So first of all, I want to reiterate what Senator Barrow said. When we have people testifying before us for a bill or a resolution in this case, we only have to go by what they say. We don't have any other thing to go. So that 9 minutes or 8 minutes, whatever you said, that whole committee voted on that. It wasn't just the person who brought the resolution.
Right.
So that's how the process works, and so that's what happened.
I've testified probably hundreds of times.
I didn't realize that Senator Fields was bringing that resolution, and after he brought it, I went over and I asked him, because I had heard from numerous people about East Baton Rouge Parish Court, if I could co-author the resolution. And I'm glad I did. He was very gracious and said I could, and then he left and went to Congress. So I have followed through. I was determined that I was not going to turn that over to the Supreme Court, and nothing happened. So I followed through. I have been doing my research. I've been interviewing people, and I've been going to court in order to see what goes on, just like Senator Barrow said.
Well,
so I'm sorry that you don't think this is something that we should look into.
No, I didn't say that. I
Because
definitely didn't
everybody
say
that
it was
has
something that you
testified
should.
has said that we should.
I'll-
We appreciate your testimony, but I just wanted to get that on the record.
I appreciate
Thank
your
you.
interest in domestic abuse in the East Baton Rouge Family Court.
Sure. And
Thank you so much, Representative Edmiston. I just want to kind of follow up, because I know you're not the only one. There's been several other members who have attended as well. I will say this. I think I need to say this, because this is something that kind of made me a little concerned. When we had our last hearing, and I got a call right before the meeting where somebody wanted to talk to me that I had not heard from in a long time. They wanted to hear what we were going to be discussing. Somebody from the judicial branch wanted to know what we was going to be discussing with the judges, and that I had not heard from that person in a long time. I did not talk with them. That gave me concern and a pause too, because someone I had not heard from. Someone from the judicial branch had them to call me, trying to get information about where we were going with this. That's the phrase that I was given. Like, what's happening here? So I don't understand where there seems to be some level of impropriety in terms of trying to ensure that we are following the law, A, that's number one. B, addressing gaps and concerns in the law, which is our job and our responsibility, number two. But then individuals who may be trying to, in some instance, I feel almost like quelch the voice of those who are speaking. And I'm hoping that is not what's happening, but it appears that way. As I've listened, because I try to see, and that's just how I want to say this. Growing up, one of the things that I think has been one of my greatest strong points is my ability to hear from all aspects and to evaluate things fairly. I think that I've done that very well, but that also can be a weakness, right? And so I try to make sure that I take everything into consideration and hear. So when you talk about individuals who have not been honest. I think for the most part, we can read through information when it's not presented to us properly. But at the same time, when we continue to get the same complaints from different areas, I promise you, when we were in here, I think last time, the stories were so familiar. I was like, I had to look at the people twice because I'm going like, did we already talk about this?
I was watching.
Yeah.
I was watching.
So something is wrong.
Mm-hmm.
And that's something I think we all recognize. Whether or not people are always telling us the truth, we cannot control that. But what we do need to do is address the areas of the law where we know that it is fairly our most vulnerable, our most valuable asset, which is our children.
Mm-hmm.
So I am committed to that wholeheartedly. I'm going to do my best to make sure that I remain very objective. But at the end of the day, I want to make sure that no one leaves here, no one that hears my voice can ever misconstrue this. I am always putting the children first.
Absolutely.
Yeah, in my decision making. Always putting the kids first. So I'm going to let you close us out, Mr. Ducote. I don't see any other questions, I think, from nobody else on the committee. And so this will wrap us up.
I just wanted to clarify one thing that I didn't touch upon, and that is collaborative divorce. Collaborative divorce is a great process, except in cases involving domestic violence, child abuse, child sexual abuse. It's precluded on its face from that process, just as is family law mediation. Those are totally different situations. It's not about people getting along and working things out. It's about protection and bright, bold lines being drawn. So just wanted to clarify that.
Okay. All right, then. Well, I have to one quick question I have for DCFS. So I have a question. Let me see if I can find the right quick here in my notes regarding, we have a question for, so I have a question. Oh, okay. Dr. Zena. Somebody so I brought him up, and I'm trying to remember who responded. It was Judge Landry. Is he still working with DCFS? Okay, so you guys are still contracting him out to do. Okay. I just will follow up up with her. Okay.
Dean Landry brought him up.
Yes. I follow back up with her, but I want to make sure that he is also still working though with the department, and he's working directly with.
He's got a couple different arrangements with the department, but TCAT is.
Okay.
He's working with us with TCAT for sure.
Okay.
Standpoint, and then TPEP as well.
Okay. All right then. So this will be conclusion for our meeting of today. Do we have the last meeting for this year set? November 12th? That's a Wednesday? Is that after election day? Is that election day? November 4th? Okay, so November 12th. So the next meeting is November 12th, at 10 a.m. Does that work for mostly everyone? Okay, and again, we will have law enforcement, schools, good, yeah, and IT. So any questions that you have along those lines or be thinking about, please be prepared. And after that, I will begin to have our follow-up meeting to begin to look at our legislative packet for the upcoming session. Session starts in March, and so most bills have to be filed by February, so we won't have much time with the holidays in between. All right. Again, I just want to thank everybody for being here. I do apologize. I did not expect this meeting to be as long. Otherwise, I would have provided lunch. So I have a motion to adjourn. Okay, Mr. Hanneman, motion to adjourn.